and asked to remain on high protein diet for 2 months, my lord. He's asked to remain on high protein diet. And again, after 2 months, he's advised to visit the Tata Memorial Hospital, my lord. And these are the medical documents, my lord, which I have annexed. The conditions which your lordship has given, he has obliged all the conditions, my lord. Even he has taken permission from the special judge to go to this Tata Memorial Hospital, my lord. And thereafter, my lord, while he was being treated at Mumbai at Tata Memorial Hospital, he was advised to remain on high protein diet and again to revisit after 2 months. Therefore, my lord, I am praying, my lord, probably, my lord, his days are counted, but still, my lord, at least he should have the proper medical treatment and everything, my lord. I pray before your lordship kindly, either your lordship will make it absolute
When
or
you
at
are
least.
planning to go,
Pardon?
when you're planning to go second time to the Tata Memorial, is there any date fixed by you?
Yes, after 2 months, and during these 2 months, he is advised to remain on high protein and extreme medication. Food is prescribed that he should remain on high protein diet because cancer patient, my lord, mainly treated with protein, my lord. Otherwise, this the high dose
No, when
medicine.
you go again for checkup.
Yes, after 2 months, he is directed. We are now in March, April, May, maybe in June again he'll go. So that's my prayer, my lord. His days are counted, my lord.
Yes, other side, yes. You're appearing on behalf of Mr. Kyle. Yes, am I audible?
Your lordship is audible. Your lordship is absolutely audible.
No, the other side, yes,
Lordship,
who is appearing?
am I audible?
What do you want to submit?
Lordship, am I audible?
Yes.
Lordship, in my humble submission, the extension may not be granted. Lordship may give a direction to the jail authority. He has to surrender before the jail, and Lordship may give a direction that the proper medication and strict diet may be taken, Lordship. This is my humble submission, Lordship. And after 2 months, he can file again the IA for interim and go for the treatment, Lordship.
My lord, we are finding
this is my humble submission, Lordship.
We are finding it difficult to. People are finding it difficult to stay alive while infected with cancer, even with the best of medical treatment. And my friend is of the opinion that a cancer patient can be treated inside this jail, my lord. I don't have, my lord. There is something also called as humanity, my lord. He has not violated any condition. I am appearing for him both while the initial bail application was moved. 1 day before the date expires, we have moved an application to the registry to get it through video conferencing. My lord, we are taking all steps. My lord, we are not at all, we have any intention to jump or to violate the condition imposed by this honorable court, my lord. Just, my lord, your lordship's little accommodation may save this life, my lord. Even for a prosecution also, my lord, they cannot prosecute a dead body, my lord. We know, my lord, what cancer is to this society. And this is blood cancer.
Okay. Hard Mr. M. Dismas, Council for
Please, your lordship. If your lordship is considering the extension, lordship, your lordship may be pleased to fix it on Wednesday. Mr. Kyal will submit on if your lordship is granting him interim or extension, lordship. Because this is my instruction that the extension may not be granted, lordship.
My lord, they cannot dictate the court.
My single bench, in fact, just after completion of the division bench,
yes.
As per request of the registry, it was put up. Then again, it may be not be possible. When Mr. Kyle is coming, in fact.
Lordship, Mr. Kyle is on, right now he's on legs in court number 12, lordship. So after some time, it may be taken, lordship, or on Wednesday, lordship.
My lord, Wednesday would be late in the sense, my lord, because the order of the order of interim.
Order of interim was 11.
11. It will expire on 11.
In that case, we can do one thing.
Lordship.
If you insist that Mr. Kyle submit, in that case, today is Monday. So till next Tuesday or Monday, it may be extended and matter may be heard and decided. Otherwise.
Lordship.
Okay.
Yes, ma'am.
Heard, Mr. So-and-so. And you are Mr.?
K. Jain. K. Jain, Lordship.
A. Jain appearing on behalf of, yes, T. Jain is appearing on behalf of Mr. A. Kyle, Mr. Kyle, the learned standing counsel. This is for NCB or
Yes,
NCB,
Lordship,
NCB.
NCB.
NCB? Considering the submission of both sides, let the matter be again listed on next Tuesday will be which date?
My lord, barring
18th.
my lord,
18th.
my lord, can it be on 19th, my lord? 18th, I'll be in Delhi, my lord. 19th, Wednesday.
Okay. 19th. Until then, the interim bill granted to the petitioner dated 11/12/2020 may be extended till next date of listing. Okay, we're extending till next date of listing, that is on 19th. And 19th matter will be heard. I'll be there in the principal seat. It will be easier for us also to continue.
I'm deeply afraid.
Okay, till 19th we are continuing.
I'm deeply afraid.
Much okay.
Okay.
May I please, Your Lordship? I beg to mention item number 21, my lord. It's a hearing matter. The respondent informed me that today he can't attend before his court, so it may be listed after 1 week, my lord.
You are appearing on behalf of respondent.
Yes, no, I'm appellant. Respondent informed me that he wants to
Name of the respondent is not reflected here in the item number 20. Who is he?
overphone cleansing XL1 Gombo from Bomdila, my lord.
What is his name? Now? What is
Gombo
his name?
Sering.
Huh?
His name is Gombo Sering.
Hearing.
Yes, this ring. Yes.
Part Mr. Hudeka, the learned counsel appearing on behalf of the appellant, and he submitted that the learned counsel for the respondent, Mr. G. Seni, informed his personal difficulty in appearing before today, and accordingly paid for an adjournment. Prayer allowed. List the matter accordingly. When do you want to list? When do you want to list?
2 weeks, my lord.
After 2 weeks?
Yes, ma'am.
List accordingly after 2 weeks.
Of the
May I, Lordship? Lordship, I would like to mention item number one, Lordship. I will be allowed to withdraw, Lordship.
Withdrawal? He got arrested?
AB, Lordship.
No, he got arrested or what?
Not arrested, still not arrested, Lordship.
But you want to withdraw?
Yes, Lordship, with a liberty to file appraisal. There is some technical defect, Lordship, in my petition, Lordship.
Your Lordship, in fact, it was not maintainable per se because there is a order from the Supreme Court where he was directed to surrender, Lordship. So AB not being maintainable. However, I leave it to Your Lordship.
I'm for the-
But he is not submitting.
Yes.
That regard.
I'm for the victim in this, my lords. I'm seeking permission. I'm seeking permission. Maharaj, I'm seeking permission in item 1.
Petition. And also heard Mr. TG, MST in the learned additional PP. It will open one of it. County. Learned additional PP appearing on behalf of state respondent. It is submitted by Mr. G. Bam that due to some technical reasons, he wants to withdraw the same as per advice of the petition, bring with a liberty to fresh file, liberty to file a fresh prayer allowed. Matter is accordingly disposed of on withdrawal with liberty to file a fresh. Otherwise, as far as it's not maintainable.
It's not maintainable because there is already a direction from the apex court, Your Lordship. Deeply.
Much obliged.
May, Lordship. Lordship, I beg to mention item number 12. Lordship, I'm really sorry. On the last date, I have picked this matter for today. Lordship, however, the senior counsel in the Bata today also is not available to some person different.
But the submission from the other side, we have already
Heard already.
regarding the maintenance.
Yes. Since Lordship will be in principal bench from next week, kindly this matter may be fixed on 24th. So Lordship will be convened for Lordship.
24th.
Yes, Lordship.
The legal counsel also may appear before the principal seat on 24th.
Yes, my
in
lord.
that case.
It can be done
So
through
he is not-
virtual.
No,
Regard-
virtual.
Well, regarding, man, we'll be attending from virtual only. Regarding,
No, virtual is okay. Most possibly, Mr. Your
Dilip,
Mojumdar is appearing.
yes, yes.
So he can appear.
Yes,
to the
yes,
principal
yes,
seat
he can,
also.
yes, he can.
Otherwise, it will be convenient for us also to hear
Yes,
the matter.
yes,
His part I have already noted down. He
Yes,
has already
yes, ma'am.
filed. And the other one I'll see.
madam.
Do one thing.
Only-
The show me the record to do. Item number 7, item number 12. Mr. Pathak is not here today.
Yes, yes.
Only my submission, madam. In case if it is permanently transfer, in that case, madam, we have to take instruction of the.
No, we are not on that.
Ma'am,
Permanent
ma'am.
transfer, we are
My
not
lord,
permanent
my lord,
transfer. Because that part, matter
Yes,
is to hear only.
Madam, yes,
This copies
Yes.
will be there in the principal seat, we'll hear the matter only.
Ma'am.
That much.
Ma'am.
In one matter also, that was done. in
yes,
this
yes,
one.
that is fine.
No, take this one. Later on you give me this. I wish I had recorded. It will be very well. Because I have noted down something, that's what I will
Yes,
take
yes.
out with me by principle. File to, what file will go, I don't know, at the principal seat, we matter maybe hard at the principal seat. I'm not passing any order here, or yet order should be there.
Okay.
Only it may be fixed on 24.
We are fixing it on 24.
Yes,
If it is, suppose if any reason it is not possible, we'll hear it better through in virtual mode. only.
Yes.
Otherwise, it will be.
Deeply on.
All right.
Request military learning council for the respondent. Let the matter be listed. No, otherwise you are there for the petitioner, na?
They are for petitioner, I'm
Election
from,
petitioner,
yes.
yeah, for the respondent.
And for the petition.
Election petitioner, list the matter accordingly on 24.
Deeply.
Only matters will be listed, on 24. Okay.
May it please your lordship. Lordship, I beg to mention item number 3, lordship. Item number 3, lordship. I am for the respondents here in lordship.
Have you taken consent with the
yes,
other side, the petitioner side?
Already taken consent, lordship. This matter may be posted on 13th of this month, lordship.
13 members. 13, we are not going to fix any.
Then
13 we cannot.
On 17, man.
If
At least 17 can be, otherwise 13 we are not going to.
Oh,
17.
on 17, man. And in
So you are for the petitioner.
yes, I am the petitioner. And in the meantime, interim is there. This may be.
Interim was there. 17th of fixed going, interim be continued till next date of fixed. So we are fixing it on 17th.
All right.
Interim be continued till next date of fixed. Okay.
May I, Lordship? Lordship, I like to mention item number 19. On behalf of T. Tapak, a senior was instruct me, he is not ready to argue. So matter may be listed after 3 weeks.
Why is not ready to argue?
Just instruct me,
Prepared.
not prepared.
You are Mr.
B. Sibo.
And Mr. B. Sibu, appearing on behalf of Mr. T. Tapa. For the applicant who paid for an adjournment. Stating that due to his personal difficulty, he is not in a position to argue the matter. List the matter accordingly. After 2 weeks will do.
Yes,
List
Lord.
after 2 weeks.
May I, Lordship, another item number 9.
Yes,
Uh,
it's a bail hearing AB.
yes, Lordship. Lordship, this matter may be listed after a week.
Here, we have the case diary in item number 9, AB. Who is dealing with? Jenny, you are dealing with?
My colleague El Hagi is there, Your Lordship, if Your Lordship pass over this matter for adjournment, I'll just call her. if-
He is paying for an adjournment after listing after. Just I want to ask you whether the CD is available. If it is available, we may pass an order for retaining the
Yes,
same if
I'll-
it is listed after.
I'll get back to Your Lordship in 1 minute.
Okay, then. To list adjourn corridor and but he will list you keep it. Otherwise, you list it after 1 week. Rest you keep it. If it is CD is dead, then it will be retained after one till the next date of listing. Okay. If it is not available, then it's okay. We should remind it.
Your Lordship, I beg to mention item number 4. I'm on behalf of Senior Counsel B. Arun. Your Lordship, I pray that the matter may be adjourned for today because the leading counsel is at the moment not present at station and due to medical emergency. So
Due to medical emergency, it's not present. Yes, so
matter may be fixed for tomorrow?
No.
No.
Also matters are fixed.
Or
This, it may be fixed on 18th of this month.
18th of this month?
Yes.
Okay.
Because 17th also there are some matters that have been fixed. So let it be on 18th.
Thank you, Your Lordship.
18th.
Yeah, Madam. Madam, I beg to mention item number 5 and 6.
5 and 6.
Yes, Madam. Madam, the conducting counsel, Mr. T. Sunil, is having some health difficulties.
Who is your leading counsel?
Mr. T. Sunil.
He is Sunil.
Yes, madam. Item number 5 and 6.
He is not available today.
Yes, madam. He is having some
You are for the respondents.
Yes, I'm for the sole respondent. Your Honor, in this case, they have taken several occasions. Time and again, yes, Your Honor. This, I think there's 4 times. One fixed date may be given you afterward.
Afternoon.
And there is a stay in the CRP, Your Honor.
In item number 7, item number
5 and 6.
6, Your Honor.
5, so there one interim is operating.
Yes,
Item
yes.
5.
There is an interim, madam.
In item number 6, CRP, there's interim, Your Honor. They are enjoying interim, Your Honor.
In last occasion also, most
Yes.
probably on the same ground, you took an adjournment.
Madam,
See, this
And
is
before that also, Your
proper,
Honor.
in fact.
I thought the leading counsel is actually having some health issues.
Here nowhere it is mentioned that he has some health issues. He is stated he is on the out of station. Who is your leading counsel, you see?
Mr. T. Sunil.
Health issues going to come for the out of station. However, in this context, you are,
Your Honor, may, fixed date may be given in this.
you are Mr.
Mudang po. I'm for the sole respondent, Your Honor. In both.
In body matters.
Yes, Your.
Madam,
Your name is
Madam, can you please
5 and
list
6. Actually, so and so appearing, the above so and so raised objection and submitted that the petitioner's side is praying for an adjournment of the same ground since last 3-4 occasions. Accordingly, he submitted that one fixed date may be fixed and matter may not be and prayed for not and not to adjourn the matter further. Considering the submission made by the counsel for both sides, let the matter be listed when it can be convenient. Your
My
leading counsel is suffering from which type of problem? Which sort of problem?
Recently, he was operated.
Operated.
Yes.
You have a tooth problem, actually. Tooth problem.
Tooth problem.
Yes. He was operated in treatment.
But
The
tooth
gums.
problem is also very
Yes,
dangerous.
yes.
You
Yes,
may
yes.
not be in a position. So let us take which date will be convenient for you. it, issue reminder, list after 1 week. 1 week. Okay, we're listing it after 1 week, we issue reminder, proceed.
Deeply.
Various lawsuit. Lawsuit, this is an application under section 528 of BNS, quashing of the present Itanagar PS case number 15/16 under section 241, 223, 34 IPC. Lordship, the present case is pending trial before the learned JMFC court, UPR. However, Lordship, on dated 24/6/2024, the accused person, along with the informant and the victim, they have undergone a compromise deed and settle the matter outside the court. However, the case being non-compoundable in nature. So Lordship, as such, they have come before this honorable court for quashing of the present case. Lordship, petition has been filed jointly by the accused person and the informant victim. And regarding the stage of the case, Lordship, so far, none of the evidence of the prosecution witness has been recorded.
Charges already been.
Yes, charges has been framed. Lordship, here in this case, as many as 6 accused person has been charge sheeted by the IO. However, out of that 6, 5 has been declared as child in conflict with law, Lordship. Only now, the petitioner number 1 before this honorable court is the only remaining accused person who is facing trial before the learned trial court.
Yes, may it please your lordship. Your lordship, even though the other accused are minor, your lordship, the piecemeal settlement is not permissible, your lordship. Your lordship, if the accused has entered into agreement with the whole, along with all the accused person, your lordship, then your lordship may consider their plea for settlement, your lordship, on mutual settlement. However, your lordship, it's a piecemeal settlement, your lordship. He is only settled with the victim person, your lordship, not the other co-accused, your lordship. Although they are minor, but they are not in the agreement. And your lordship, this issue regarding the piecemeal settlement has come before the Punjab High Court, your lordship, wherein your lordship, the matter was referred to the larger bench, where it was held that the piecemeal settlement cannot be done, your lordship. It has to be entered by all the accused and the victim. Then the court can, your lordship, exercise its inherent power, your lordship. Because it is not a case where they cannot be proceeded against the minors also, your lordship. Although they cannot be convicted, but they can be found held in conflict with the law, your lordship. If they found, then your lordship, there is a specific provision under JJB Act. But here in this case, your lordship, only the present applicant, that is the victim and the accused, they only enter into an agreement, your lordship, not the other.
Yeah, the minor.
Yes, your lordship.
Regarding those minor, the case has been already disposed of before the juvenile justice board.
Have you annexed anything here?
No, that has not been annexed.
Okay.
Lordship,
Fix a
record may
date.
be called for.
Record will call record in sense from the JJB.
No, Lordship, record in the main case, there
Record
itself.
in the main case we are going to call for this.
Yes.
When
And
you're saying that the matter is the JJB has already been disposed
Yes,
of,
yes.
can you just file in this copy of order, certified copy of order through an addition?
your Lordship,
If it has already been disposed.
Lordship, the date fixed before the trial court is on 18th of this month.
18th of this.
18th of this month. So before the lower court record comes, the matter may be stayed.
Before 18th, up to 13th, we are not going to fix any matter. At least 17th can be fixed.
Lord,
17th.
Till then, Lordship, matter may be stayed. Proceeding of the lower court may be stayed.
Heard Mr.
Titawa.
the learned counsel for the petition, and also heard Mr. E. Abdul, the learned petition, he appearing on behalf of state respondent. This is an application for so and so. Issue notice to the respondents. Stop, no further, no formal notice is required to be served on the respondents, as state has already appeared to a disqualification. However, extra requisite copy may be served during the course of the day. Call for the scan copy of the also. In the meantime, the petitioner will also file the certified copy of the order passed in. Can you tell us the date? I mean, case number in the JJB?
No.
Case certified copy of the case which is pending, which was pending before the JJB to an additional affidavit. The registry will take necessary steps in calling this scan copy of the LCM. Next paragraph. Considering this submission made by the counsel for petitioner, if further proceeding be stayed in next date of listing. Further proceeding in case connection with so and so be next date of listing. List accordingly. In that case, if you have stayed, then let it be on 18th then.
Yes, your lordship.
Otherwise, yes.
Yes, sir. The issue of maintainability we kept open, your lordship.
Next paragraph. Out of the Mr. Rete also raised the issue of maintainability, which may be kept open for the hearing on the next date. Matter may be listed accordingly on 19th. So, I will stay for the till next date of listing. Okay. Okay, we are 19th, and there will be a stay, and he raised the issue of maintainability that
Yes.
may be hard.
Yes. Oblige, your lordship.
My lord, there is subsequent development in this case. What had happened during operation of the interim order, the village authority went ahead with passing the order. My lord. This I discovered. Kindly have this page 15, my lord, of the affidavit in opposition filed by respondent number 1, 2. Where are those orders? My lord, before this, my lord will kindly have this order dated 4/10/2024.
59 is
Correct. With the
59.
59 of affidavit in opposition, my lord.
It is an order.
Yes, ma'am. Well, before that, my lord, kindly flash back to order dated 4/10/2024, my lord. It says
Where is
when
the order?
yes,
Order is the
Yes.
page number?
well, yes, my lord. There
No,
was
no, page number.
No, it is not there. It is in the order.
Oh,
In
your
fact-
order. Achha, okay.
Well, I read for my lord.
410.
Yes, 4/10. It says
Yes.
having regards operating portion is page 3. Having regards to the contention made by the learned counsel for the petitioner, comma in interim, comma, it is provided that the mail order notice dated 9/9/2024 issued by the president of all Damin Panyasing Gambura Welfare Association by fixing the mail on 10/10/2024 at Damin shall remain state till returnable date. my lord. Now, my lord, then what happens, my lord, kindly come to page 59, annexure D of the affidavit in opposition filed by the respondent number. Anya, what is this? 1 and also for 2, my lord, 1 and 2. Now, my lord, what had happened? Kindly see, during operation of the interim order, the order dated 10/20/25 has been passed. It is not my documents, my lord. It is brought by the counsel for the respondents. So,
10, 10.
10, page 59, my lord, affidavit in opposition.
Opposition.
By respondent number 1 and 2, my lord. नहीं 25 24 it says 24 24 it says
24
ठीक है correct 24 my lord.
Not 59, I think.
Page 59 is. Well, may I help my lord in finding the other copy?
59 is different.
No, कर देगा फिर।
Yeah, yes, yeah. Okay. It's 60, my lord. It is wrong. You have given me a wrong copy.
No. So there might be numbering.
Yes,
से कहता है।
That's right. That's right. That is a typological mistake. It can always be corrected.
So this is the order,
Yes.
is 60.
The last order either. The my lord has seen that order, the interim order was passed by this honorable court on 4/10/2024, and then the interim order has been passed. So rightly or the wrongly, my lord, I have to seek instruct. This order has been passed, meaning on a cursory reading of this order itself, prophesy a contempt, my lord. Because the court below ought to have maintained the judicial discipline. When the superior court is in session of the matter and there is an stay order, my lord, he is not supposed to exercise the jurisdiction.
Because 1010 was stated.
Yes, my lord. So therefore, my lord, I will seek instruction from my client as to whether, because there is a new course of action has arisen, my lord. By virtue of this order, the two things are happening. Because the lease involved in the read petition has already been adjudicated by the learned one. And number two, during pendency of, during operation of the interim order passed by the honorable court, prima facie has committed a court. But if we look at section 11, Lord, prima facie, this court can have the suo motu contempt proceeding drawn against that. But for the moment, my lord, because whatever the village authorities, they are not really educated. So for sake of brevity and balancing the equity, my lord, just let me seek the instruction from my client as to, because to me, my lord, two things, because the course of action has already been decided, and then probably a contempt. So I'll get back to you. I think
Okay.
maybe after
May I?
2 weeks.
It's very simple. There is a issue is only that this village authority doesn't have jurisdiction. That was the main.
Come later.
Okay, now here, yes.
That
This
obviously by order.
yes,
10,
yes.
There was a stay.
The stay was passed on 04/10/2024.
Yes, yes.
And the customary that proceeding has been started from 2023. This case.
That-
Now here that order was passed after 5 days. That's 10/10/2024. After 5 days. And if your lordship may see the order dated 3/12/2024, where it has been clearly stated that the respondent and they had received the copy on 28/11/2024. So thereby it means it's a duty of that party to serve the copy to that village authority, that it has been already stated. So
you
you
want to say that on 1010 there's no copy was served.
yes, and it was served in the month of November, and order was passed in the month of October, one 1 month back. So
Let me
how?
take instructions then in that regard.
Yes.
If that may be the position, I don't know.
Yes, lordship. So it's on record only. Everything is on record. And the proceeding has started initially there before the Civil Judge Senior Division 0. But later on, they have dismissed their petition by directing that, by applying the principle of res sub judice. Since the village authority is also authorized under Section 3, Clause E of AP Civil Code Act 2021. They are one of the lowest civil court in the state of Arunachal Pradesh. Relying on that, they directed to appear before them. And as per the page number 54 also, in the civil judge senior division 0 direction, it's very clear that both party has approached there and they had selected that as a customary forum and they want to determine the case. Meanwhile, after fixing that, they had suddenly, before the conduction of that hearing, prior to 5 days, they appear before this court just to stay the proceeding. So there is no dispute regarding jurisdiction. So they had just approached this court, they doesn't have jurisdiction. So that's the issue,
Merit.
Lordship. So later on, that may be fixed if.
Well, on merit, I'm not entering now. I reserve it for
Yes, obviously.
my argument. But from Apasai, to my mind, if we appreciate the object of contempt of the court, it is a usual practice. Once any impugn order by any authority, including the lower court, the moment it has been brought before the higher court and there is a interference from the higher court, even that order will be effective and operative from the day it was pronounced in the moment it was pronounced in the open court.
But he raised another issue that it was
Yes.
that the
Yeah, that's
copy was not served on them up
Yes.
to 28/11/2024.
let
That is the
let
real
me
issue.
therefore,
Uh-huh.
I thought it because like just I have gone through, even I have not put out in the liquid text also.
Oh.
So on perusal of this, I find that either something has gone wrong either way.
Okay. But Mr. Dave, Ilan Council for the
Date,
petition. I also take it on now.
Date you find out.
What's the good name?
Tanya Kipa.
Keeper, the learned counsel for the respondent. The matter was fixed for admission, but it is submitted by Mr. Tara that from their affidavit in opposition, it is seen that there was a mail held on 10/10/2024 in spite of the order passed by this court dated 4/10/2024. The proceeding under the mail of the proceeding was stayed, which was scheduled to be held on 10/10/2024. Mr. Tara he submitted that he needs some instruction from his client, and though it apparently appears to be contempt of the court.
If I assist the court to an extent as to whether the order dated 4/10/24 passed by this honorable court was served to the respondent.
That will come later on.
Yes.
That's again, Mr. Next brother. In that context, Mr. Kipa, the learned counsel for the respondent, submitted that there was a no contempt of the court proceeding, and the order of 4/10/2024. The copy of order of 4/2024 was served on the respondent only on month of November, that is on 28/11/2024. And both the parties, as per you, both the parties appeared also.
Yes,
Both the parties
no,
appeared.
other party has, means they were supposed to appear.
But they have not appeared.
Yes.
And in the meantime, the order was passed on 10/10/2024. Next paragraph. Considering the submission made by the learned counsel for persons, it was to be seen as to whether the copy of the order was served on the other side before 10/10/2024, and the matter is also matter with in the meantime, the learned counsel for the petition, Mr. Tara, will also obtain instructions in regards to the service of notice as well as
Till then, may I propose that this impugn order has been brought to notice recently, 2 days, and this impugn order, my lord, shall not be given effect to till the instruction comes. That much my lord can interfere with, because it will be balancing the equity only, because we have not participated.
In this regard, Lordship, they can appeal this order
No, no,
and they can recall the order also if they approach there. Yes, there is a provision is there. Section 15 clause 4.
Till it takes instruction, it is to be also seen as to whether, as per your submission, whether it is correct that
Yes,
the,
yes.
The copies of those orders and all were not served to the other side on or before 10/10. And it was subsequently on 11. That matter is
Yes.
also to be seen.
Yes.
And in the meantime, Mr. Tara will also take the instructions in that regard. So let it will not affect otherwise also, if
Yes.
it then can be, okay. Next paragraph, further considering the submission made by the counsel for the petitioner, let the petitioner, the order
Dated
dated 10/10/2024 passed in mail judgment,
yes.
MEL, mail judgment, as per Nishi customary, so and so, may give effect till
Great.
instead of listing.
Great. Second,
Uh,
let it be
right.
on 2nd April.
Pardon?
Second, list it on 2nd April.
2nd of April.
Yes. In between, I'm out.
Confirm.
Yeah, 2nd April.
Why are you saying that he is
No,
confirmed?
he's senior, so I have to ask him. Otherwise, if I fix it, so I,
I'm thankful to my
yes,
brothers.
that's why. If he
So
confirm,
you're
then
maintaining protocol, na?
Grateful.
2nd of April?
yes,
2nd of April. We're
No,
listing it on 2nd.
Not required that.
highly.
Lordship, this case is wrongly listed in hearing list, Your Lordship, because in 4 occasions after filing of this bail application, the petitioner didn't appear before this court, right from the first day itself. Now this is the 5th time this is listed, Your Lordship. From 4 to 2025, from February. Every occasion, Your Lordship. Maybe dismissed for default, Your Lordship.
Mr. D.A.T., the learned counsel, learned additional PP appearing on behalf of state respondent and appears on call for the petitioner side. And it is pointed out by Mr. A.T. that since the date of filing, the petitioners remain absent on call. Accordingly, he submitted. It is a fit case wherein the bail petition can be dismissed due to non-prosecution. Next paragraph, after hearing this submission made by learned counsel for learned additional PP, I have to take this record. And it is seen that since the day of filing, the petitioners remain absent without stay. And accordingly, the bail petition is thereby dismissed due to non-prosecution. Okay.
Deeply obliged.
Lordship, on previous occasion, the accused was granted one more chance to appear before the IO, Your Lordship. However, my CD does not reflect if she has appeared or not. An updated CD may be called for in that case, Your Lordship.
Lordship, in that case, I may be allowed to withdraw this application since we have also been trying to contact them. We have not received anything, instruction from them. It appears that she's no longer interested.
There is, yes.
You could not contact with him.
No, Your Lordship. That is why I may be allowed to
You
withdraw
are
this.
Mr.
M. Tangsang.
M. Taza, you are appearing on behalf of whom?
My name is in the Bakalat naman, Your Lordship.
We are on item number 11, isn't it?
Yes.
Yes, sir.
Though it's not
Your
reflected in the
name is
clause
under-
list. Though it's not reflected in the clause list, Your Lordship, my name is in the Bakalat nama.
In Wakalatama?
Yes.
So M. Taza,
Tangsang.
Tangjang.
Tangzang.
Acha.
T-A-N-G-Z-A-N-G.
Heard Mr. M. Tangjang, the learned counsel for the petitioner. And also heard Ms. T. Jenny, the learned additional PP appearing on behalf of state respondent. It is submitted by Ms. Jenny that in spite of giving chance to the present petitioner, he did not appear before the IO and his statement is not available in the case diary. In that context, Mr. Tangjang, the learned counsel for the petitioner submitted that not contact with the present petition, contact with the petitioner, and in spite of his direction, he has not appeared before the IO, and accordingly, he submitted that the present petition may be, and accordingly he submitted that he doesn't want to press the petition further and wants to withdraw the same. Considering the submission made by the counsel for both sides, that the present petition be disposed of on withdrawal. CDB return?
Yes, yes.
CDB return.
Deeply obliged.
Obliged, Your Lordship.
What is the next item? 15 is for order. Matters are then. Okay, then you just call the 13. Why it is in order call? Services still awaited here? Yes. What does not say? In fact, fresh steps for service completion. Taken. You have taken the fresh steps.
Yeah, we have to take fresh step now.
Pardon?
No, not yet.
But office notes speaks that you have taken fresh steps on respondent number 2. On the last, this one that is on 4/2/2025, there was a note from the registry that you have not taken steps, fresh steps. But on as per 7/3/2025, I don't know why it is different. There's a fresh steps for service of notice upon the respondent. Oh, it's not yet taken. Why you're not taking steps?
We need more time.
Why? Could not collect the address or what is general?
Your Lordship, I have no idea. I have to ask my senior.
If I appear before any court, just take some instructions at least. So your state is 1.
Yes, Your Lordship.
It's a case of what?
Your Lordship, Mr.
It's a case
Tado.
of criminal petition.
Yes, Your Lordship.
For quashing? You are not aware of any cases quashing. Hard MS, you are MS?
P. Borang.
P. Bora?
Your Lordship, interim may be continued.
No, what's your name?
P. Borang.
P. Bora?
Borang.
Oh, acha, Borang. Acha. So and so, and also hard MS TGD, demanded additional PP, payment have of state respondent. As per office note dated 7/3/2025. No fresh steps been taken on the respondent number 2. And in spite of the report, accordingly, the petitioner side is hereby directed to take steps on the respondent within 2/3 days. And list the matter accordingly after 3 weeks. You take steps within 2-3 days or next week. Within next week, you take steps. Let us see if comes. So otherwise, we are listing it after 3 weeks. You need any copy, record, etc. here?
Nothing is such, Your Lordship. Because I don't have the brief, Your Lordship. I can just
have the brief.
Yes, I'll just.
No, if you need anything, then we may call for. That's why.
Yes, Your Lordship. In that case, since the charge sheet has already been filed, if the scan copy of the yes,
Scan copy of the TCR be called for. Registry will be. Okay, we are calling it. Let the copy be there.
yes, Your Lordship. Deeply.
Auskunft werden vor das Mikrofon.
Yes.
May I please about you? No. Get Auskunft here. My lord, this is the land acquisition act. And facts of the case is there.
So why it is in order column? In fact, why it is in order column? Why it is in order column?
Oh.
Cases are listed in order column.
Order,
Why?
actually, what happened? This is only for I.
I.
Yes.
Watcha, which
I.
that is I 231.
Oh, my lord, this is 231. 231, yes.
231.
But I'll argue from the main case. Actually, facts of the case is that, my lord. In all of India, it's Ministry of Defense, they required 530 acres of land to open the ammunition point. Accordingly, my lord, after section 40, land was acquired and 100% compensation was paid. That is near about little less than 70 cents. Then initially 80% was paid Subsequently, 20% was paid and 100% payment was made. And probably land was handed over, and it is under the Ministry of Defense. Now, my lord, after getting that 70 crores of amount, may have filed a acquisition appeal before the Lord District. And subsequently, award has been given, and price was from 150 to it was raised to 500. So that's so prior to that, my lord, just the starting point of this, just I want your lordship to go through it of a later. So how this starts, madam? This is the starting point of a letter. This is the first communication to Deputy Commissioner by the PEO. PEO is the Defense State Officer. He represents Ministry of Defense at Itanagar. So this is the first communication letter, how it is processed. For your lordship convenience, just I'm reading. Subject: acquisition of 437 acres of private land in general area, Palm Village under Basar Sahib, Laparda district, Arunachal Pradesh, for operation necessity to establish a ammunition point. Basically, this 537 acres required to put a ammunition point for Ministry of Defense. Reference to your letter so and so. Number 2. Please find enclosed here a copy of the Government of India, Ministry of Defense order number so and so, that is 16/02/2023, and sanction number so and so, that is 16/02/2023, for the subject acquisition of the estimated cost of 70 crores in general area Palm Village under Basar Circle, Leopard district, Arunachal Pradesh, for operation necessity to establish a COPS ammunition point. Therefore, you are requested to initiate the acquisition proceeding by publishing the preliminary notification under Section 11 of the LARA Act 2013 and publish the same in the State Government Gazette as well as 2 daily newspapers as per procedure vowed in complete the subject line acquisition under LARA Act 2013 at the earliest. It is just intimated that the Government of India, Ministry of Defense, has also given a sanction for invoking urgency clause under Section 40 of the LARA Act 2013 for exemption of undertaking social impact assessment study under Section 9 of the 2013 Act. Ministry of Defense has also conveyed the direction to the President of India that no additional, this is very important, my friend. They have also conveyed the direction to the President of India that no additional compensation will be paid as per provision of the Section 45 of the 2013 Act, since the President of India is satisfied that the land proposal to be acquired for the process of affecting sovereignty and integrity of India and the security and the strategic interest of the state or relation with foreign states. On completion of the mandatory procedure of the preliminary notification under Section 11 of the Act 2013, you are also requested to fix the suitable date for carrying out the joint survey of the subject as provided by Section 12 of the 2013 Act. Ministry of Defense having been notified, appropriate government, this is also important, my lord, appropriate government, in exercise of the power conferred by the Section 1 and 4 of the 40 of the right to fair compensation and transfer to land acquisition rehabilitation of the 2020, directed the DC Leopard by letter number so and so, that is 16/02/2023, that the provision of the chapter 2 and 3 of the Section 15 to 18 Act shall not apply to the acquisition. A declaration will be made under Section 19 the respective above land at the time of the date of publication of the preliminary notification under subsection 1 of the Section 11. The collector, Deputy Commissioner, Leopard District, Arunachal Pradesh, though no award has been made, may on expiration of the 30 days from the publication of the notice mentioned in Section 21, take possession of the any land needed for the public purpose, and such land shall thereupon vest absolutely in the government free from all encumbrance. No additional, this is important, no additional compensation will be required to be paid for acquisition of the evidence. In view of above, it is requested that the necessary action be kindly be initiated at an early date. So in hence here my lord, the lordship may take this back. 2000. बाकी किताबें लिस्ट दिया बाकी बुक लिस्ट दी दिया बाकी किताबें बुक लिस्ट दी दिया your lord take section 40 section 40 this is the urgency clause. Yes, section 40. The what is vested by this act? Special power in case of urgency to acquire land in certain cases. In case of urgency, whatever the appropriate government so directs, the collector, though no such award may, on the expiration of the 30 days from the publication of the notice mentioned in section 21, take possession of any land needed to a public purpose. Such land shall thereupon be vested absolutely to the government, free from all encumbrance. 2. The power of the appropriate government under section 1 shall be restricted to the minimum area required for the defense of India or national security or from emergencies arising out of the natural calamities or any other emergency with the approval of the parliament. Provided that collectors shall not take possession of any building or part of the building under this subsection without giving to the occupier 48 hours notice to his intention to do so. So such a longer notice as may be reasonably sufficient to enable such occupier to remove his movable from the such a building without unnecessary inconvenience. Means this section has empowered the property within 48 hours of the if this land is required for the sovereignty of the country for defense of the country, that may be acquired. Subsequently, 3, before taking possession of any land under subsection or subsection of the collector shall tender payment of the 80%. That is a mandatory provision. Before taking the land, 80% must go to the beneficiary, mean landowners. And compensation for the such a land as estimated to him, to the person interested and entitled thereto. In the case of any land which in option of the appropriate government in the provision of the subsection 1, subsection 2, and the subsection 3 are applicable, the appropriate government may direct any or all other of all the provisions of the chapter 2 to 6 shall not apply. And it does so direct. Declaration may be made under section 19 in respect of the land at any time after the date of the publication of the preliminary notice under section 1 of this section 11. And additional compensation of 70% of the total compensation as determined under section 27 shall be paid to the collector in respect to the land and properly for acquisition of which proceedings have been initiated under subsection 1 of the section, provided that no additional compensation will be required. This is important. When the land is required for the sovereignty of the country. Provided that no additional compensation will be required to be paid in case of project is one of the affected of the sovereignty, integrity of the India, security, and strategic interest of the state or relation to the foreign states. Well, here, the 537 acres have been acquired for ammunition point because this is a border state. And after acquiring this land, my lord, then Ministry of Defense has sanctioned about 70 crores. And duly this is approved by the land management of government of Arunachal Pradesh. And this amount has been paid about 70 crores. That is as per the price determined by the state government. We are central government. State government, deputy commissioner, or state government is the authority of the land. They will decide the price. Price is not going to decide by the central government. So deputy commissioner will take the central government what price the land should be. Accordingly, 2022 notification has been published by the government of Arunachal Pradesh stating the rate 150 per square meter of land. And after that, so many multiple factors will come, solatium will come, everything will come. If all it comes less than 70 crores, accordingly 80% has been paid. Then subsequently again 20% has been paid, 100% has been paid. After paying 100%, only land was acquired. So beneficiaries are happy, right? Then all of a sudden, in the strength of a power of a one gentleman had come without any authority, filed a reference case before the learned district. And accordingly, the district judge has heard the matter in several occasions and passed the award. Your lordship will take my LA appeal number. That one. Your lordship will find at page 20. Oh, sorry, the award is not sorry, not by the way. The award your lordship will find at 160. I am coming to the reason point of the award. This award, the whole judgment is too long. Just I am coming to the operating plan. Because today my submission was not a final hearing. This is my submission only for the stay of the impugn order passed by the Lord. That is my prayer today before your order. To stay of the impugn order. Have you got 160? I'll go to the award. This is paragraph 185. In view of the material exhibits of the parties, oral evidence, as well as oral and written argument, the award date made by the collector in his calculation at the rate of 150 is enhanced to rate ₹5. As an enhanced market value determined herein, with the recourse to the provision of the section 69 of the 2013 Act, read to the section 26 of the Act, and the petitioner should be compensated accordingly at the state enhanced rate. Therefore, the compensation for market value payable to the petitioner shall be determined at the rounded off of the ₹500 per square meter, which should thus stand at around 108 crores 65 10 crores 1086580,933 for a total area of, this is come to square 537 acres of area acquired under the category of the horticulture land instead of the area determination of compensation 32 lakhs, I think, 32 crores 59 lakhs 74,250.85. The amount is to be deposited in the court within 1 month after proper calculation of the detail. The petitioner and entitled to the multiple factors too. Here also we are having a strong objection, made. Multiple 2 as per section 26(2) of the Act. The petitioner entitled to award of solatium 100%. After this 500, they will get a solatium 100%. That becomes thousands. Or total compensation down as per the 31 read section 619 also award 12% interest under the section 33 read section 69 to 62 of the 2039. The petitioner not entitled to any cost of the petition. Judge then pronounced the open today given under my institution. According to me, my lord, this price 150 rupees not determined by the central government. that is determined by the state government, who is the guardian of the land. And accordingly, that money has been given. Then after that, all of a sudden, we call it an afterthought that in the strength of a power of attorney, even that power of attorney is also not valid, my lord. So I'll take your lordship to the grounds of my petition for LA, my lord, that your lordship will find at page 23. So I have already narrated about the section 40, my lord. Now your lordship has already gone through section 40 of the 2013 Act. Then, my lord, this is for the impugned judgment and order dated 19/10/2024, granting enhanced compensation at a round-up rate of 500 per square meter.
You're reading on which
page 23, my lord.
23.
This is my first round. Enhancing compensation rounded up to 500 rupees per square meter for horticultural land against the earlier award date by the proforma respondent and Deputy Commissioner Basar Leopard at the rate of 150 per square meter, with other components as the multiple factor 2 means it is section 26. Section 26(2), here we are having the obligation of value with 100% on our shalitum. Then it becomes a double. On the enhanced market rate along with the interest at the rate of rupees 1200 under section 30.3, section 69.2, as well as section 7280 Lara Act, and enhance the rate of 9% for first year and thereafter 15% per annum, respectively under the appeal patent and erroneous in facts of law. Here might not be 70 crores. Now it has become, after this judgment, 410 hours. That calculation is to be made by Deputy Commissioner. That calculation is made by Deputy Commissioner only. Now we have come to know, after this judgment, the 70 crores has become 410 crores. So where is 70 crores, my lord? Where is 410 crores? Nearly 6-7 times higher. And in Arunachal Pradesh, in such a place where a ammunition point will be there, though this cannot go such a higher rate. So it is absolutely exorbitant. Now the question is, my lord, this case has been filed before the learned district judge on the strength of the power of attorney. We are having a strong objection on the power of attorney. Had it been the 102 people who have come filing this my lord reference case, then it would have been something different. All of a sudden, one gentleman had come with the strength of the power of attorney and demanding the compensation for 102%. And that power of attorney also not, my lord, registered property. That was not executed property. That was done before a notary. Secondly, we are having a bona fide doubt whether those persons were practically present before the power of attorney, before the notary, 102%. Subsequently, we found, my lord, power of attorney has been signed by a dead person. As your lordship knows, as per the Power of Attorney Act, if somebody signs and if dead person, somebody signs in it, then automatically the power of attorney gets invalid. With that strength, my lord, your lordship may decree this. So this power of attorney, then my lord, I'll take to the one how it should be done. That I will come to the Registration Act, Registration Act 1908. Registration Act. Your lordship may peruse section 7. Well, it's a matter of nearly 400 courts and on this thing, the power of attorney. The learned district has allowed their offense case minor. And the registration actually, if it is above the 1 rupee, that has to be registered under this registration act. Your Lordship may peruse section 70. Section 70. Section 70 reads, my lord. The following documents shall be registered if the property of which are related is situated in a district in which, or if they have been executed on or after date on which act number so and so, the Indian Registration Act, anti-Indian registration so and so. Number 1, immovable property. So this land is immovable.
Instrument of gift of immovable property, not immovable property.
Oh, instrument of gift of immovable property. Yes.
Gift is a different connotation.
Yes. But nowadays, by the gift and it is all the same. Earlier, gift was also the stamp duty was not attracted. Now, in the gift also the stamp duty is attracted. Now, gift is also same. It is equivalent to the sale, right? So, instrument to the gift of the immovable property. So, subsequently, my lord, your lordship may turn to page 30 of section 32. So, for that notary, what are the things required? Number 1, 32A, compulsory affixing of the photograph. In the power of attorney, the photograph is a mandatory provision. Even a person proceeding to the document at the proper registration officer under section 32 affix his passport size photograph and a fingerprint to the documents, provided that where such a document relates to the transfer of the ownership of an immobile property, the passport size photograph and fingerprints of each buyer and seller of the such a property mentioned in the document shall also be affixed in the document. Then 33, my lord, power of attorney recognizable for powers of the section 32. For the purpose of the section 32, following power of attorney shall alone be recognized, namely, if the principal at the time of the execution of power of attorney resides in any part of India in which this act is for the time being in force, power of attorney executed before or authenticated by the registrar or the sub-registrar with district sub-district the principal resides. The principal of the at the time of enforcing a power of attorney executed before and authenticated by any means. In a principal at the time of enforcement does not reside in a power of attorney executed before the authenticated by it notified or any court, judge, magistrate, or vice council, or the representative of the central government. Provided that the following persons shall not be required, this is not important. This is not important. So, our contention is that when it becomes to the figure, is such a huge figure. That also
The question is that that you are challenging that the
power of
authenticity of the power of attorney.
Yes.
That's the strength of which the person.
Yes, yes. So now the power of attorney holder, he does not have this right to file this case. And secondly, power of attorney was executed by that person. That I'll come to your lordship. And moreover, there are so many other things I will come to see. After accepting 100%, the beneficiaries are very much satisfied. After all of a sudden, how this reference case has come. So, my humble submission before lordship is that the power of attorney was not executed before any sub-registered or sub-registered or a magistrate. Such a pecuniary involvement, 400% plus, should have been registered before a sub-register or a magistrate. And, my lord, in a ground number 5, your lordship will come to ground number 5, my lord. That is This is we have narrated here. Ground number 5. Here, my lord, you see how the anomalies has come. That the most important, a bare perusal of a power of attorney reveals that the same is not a genuine document. Having legal validity, as per provision of the land manual dated 6/9/22, notified for acquisition of land in Arunachal Pradesh, a deed of acceptance of compensation was prepared by the Deputy Commissioner, Leparda, at the time of disbursement. Of the compensation, which is signature of the all ex-land owners with their respective photograph. It is observed from the power of attorney submitted by the petitioner, respondent, that the signature of the owner, these are the serials number, 2, 3, 4, 5, up to 101, do not match with the signature of the owners appended to the deed of acceptance for compensation. These signatures are not delicate. It is done by, it is signed by someone else. The name of the landowners of the serial number 70 do not match. The owner of the serial number 12, 15, and 75 is 81. Put their thumb impression on the deed of the acceptance for a compensation, whereas the signatures are appended on power of attorney. There are two signatures on the deed of acceptance on compensation that to be owner serial number so and so, whereas there is only one signature on power of attorney in respect of the dues. From the above, it is clear that the so-called power of attorney is not a genuine document, having legal validity and not executed by the ex-landowner. That is one of the grounds. These landowners have not come, somebody put their signatures, my lord. So your lordship has gone for section 17 of the, this is 5, 6, 7, 8, all grounds are similar only. We're coming to that only. So now your lordship will our ground 9. That is in page 32. Yeah. Right. So I read it, my lord, 9. That there is an infirmity in the learned district sessions court holding that the filing of the reference application itself is a legal protest and an objection to the award. However, this is a matter of the strong contention, as the learned court has failed to appreciate that it is to be the case. Lawmakers would not have added the separate provision under section 77(2) of the Law Act 2020, which provide that no person who has received the amount otherwise than under protest shall be entitled to make any application under section 1 of section 64. Now your lordship make it take the act on the hand. Section 77. Yes. 77 by payment of compensation deposit is same in the authority. I am reading on 2. 77(2). If the person entitled to compensation shall not consent to receive it, or if there be no person competent to alienate the land, or if there be any dispute as to the title to the receipt of the compensation, or as to apportionment of it, the collector shall deposit the amount of the compensation in the authority in which reference under section 64 would be submitted. Provided that, this is important, provided that any person admitted to be interested may be received in such a payment under protest as to the sufficient of the amount. Provided further that no person who has received the amount otherwise than under protest shall be entitled to make any application under section 1 of the section 64. So the 100% they have received it without any protest.
At the time of receipt, whether they received or under protest?
No. That is my submission before. No protest. Peacefully they have taken, they have signed the deed of agreement that I read to your lordship. Subsequently, 20% they are received happily. They are happy. They have got an exorbitant price. Now it is afterthought coming to a reference clause. But here 77(2) says when no protest, after that they cannot file a reference case under 64(1) of the law. So on this ground itself, my lord, this appeal may be admitted and the London District Court judgment will be set aside, my lord. After that, my lord, now I will read the acceptance letter. Your lordship may turn to page 399. Page 399. How it goes. Volume 2. Chapter 9. This is you say, but not deed of acceptance. Deed of acceptance, this is the deed, my lord. This is not agreement. This is the deed. Deed of acceptance of the compensation for a land acquired under Law Act 2013. The deed of acceptance of the compensation is entered into this. Well, here this is not given, but subsequent page this is given that it 2011, 23. Second page, you are not having the
Date of issue of stamp paper.
stamp paper, because it is not Xerox property, that is the reason. So this to be taken as part of the Deputy Commissioner's signature 2011. State of ownership protest through the Deputy Commissioner and effort of the state. Herein referred as party of the first part. And name of the project affected family, beneficiary. Herein after fall is the PA, which expression shall, unless it is referred into the context of the thereof be deemed to be included or in her his or her executor successors, herein referred as the party of the second part. Indian Army, for the Deputy Commissioner at Laparda District, having its project office at Laparda District, and office of the Deputy Commissioner, which expression shall, unless it is all the mere form is way. The next, whereas the state government will issue notification by number so and so dated 23rd March 2023 under section 11. Read it is section 41, that is our section. Of the right to fair compensation and transparency in land acquisition and rehabilitation and representation Act 2013 for acquisition of subject land or properties for the public purpose, that is for establishment of corpse emulation point, Laparda District, on behalf of the requiring body, namely Indian Army. And whereas project affected family is in possession of the certain land or asset, having customary right or privilege over such a land or assets, details of land and asset under the possession of the EAF is appended in Schedule A to the deed of acceptance of the compensation. Page 401. And whereas the Deputy Commissioner, some land acquisition authority Laparda District passed the award that 1st November 2023, determining the compensation for the aforesaid acquisition. And whereas project affected family has accepted the compensation payable as per Schedule B to this deed of acceptance of compensation toward the land and asset mentioned in the Schedule A to the agreement. And whereas an amount, this is the right amount, my lord, 69 crores 10 lakhs 65 470 46 has been paid to the project affected family in his her bank account number so and so. Then they have accepted the money, it is gone for the bank money of the Deputy Commissioner. Now, therefore, in consideration of the premise of the covenants of the contained in the deed of acceptance of the compensation, each of the parties here to agree and confirm as follows. The project affected family hereby accept the amount 69 crores so and so in full and final and conclusive of the claim of the compensation against the land and accept referred to the Schedule A of the deed of acceptance of the compensation. This is important, my lord. No further amount is payable by the state government and Indian Army towards the aforesaid and asset. This is the final agreement. 100% has been paid. Then the power of a project affected family submits that this presence, that is the deed of acceptance of the compensation, including the schedule appended in it, as the extinguishment of any claims. Extinguishment of my lord, any claim. They cannot claim anymore. That is already over. Over customary right, within the customary right, and privilege over the relation to the said land or asset in fusion. As such, no successor of the project affected family shall have any right to customary right and privilege over the said land and to call into question this presence or to the sufficiency of consideration in the terms of the same project affected family. That the project affected family declares that the land or asset or are free from all encumbrance and peaceful and vacant possession of the land is hereby delivered to the state government, and a certificate of taking over possession is approved by the civil so deed of acceptance of compensation. This is important. That in case of any dispute, differences arise as regards to the aforesaid land and asset between the project affected family and the third party, the same shall be settled between the project affected family and the such person whosoever in the project affected family under this neither the state government nor Indian Army shall be liable to such person in any manner whatsoever. Then the project affected family handing the actual physical possession of the said land and assets to the state government, and the state government undertakes to hand over the actual possession of the said land and asset in favor of the requiring body, namely the Indian Army. The schedule to this deed of acceptance of compensation, which finds mention in the provision of the deed of acceptance of compensation, shall be read to the as an integral part of this agreement, subject to the provision of the same. In witness whereof, your lordship will see the 102 families here, say up to page.
You skipped one important line.
No, which line?
The schedules to this deed.
The schedule to the deed of acceptance is compensation, which find mentioned in the provision of this deed of acceptance of compensation, shall be read to be as the integral part of the agreement, subject to the provision.
Subject to provisions of the.
Yes, that is there. That is there. That is there. So, my lord, these 102 landowners, project affected family, they have accepted the money without any protest, and they are fully satisfied because they have got a price in exorbitant rate, because why? The land is in such a manner, 30 to 45% the hill. After that, it was a simply 50 to 60% with the tree there. And for defense of the country, from the northern part, why this plot of land has been chosen? Reason is there is a hill in between. If somebody from the part they throws a rocket, it won't go to the ammunition point. It will be a necessary barricade. So they have got a very higher price point. 150 rupees, otherwise no agriculture will grow. It is absolutely an abandoned road, and they have got a sufficient money for that. Now, 77. So again, I will read my lord 77(2) for your convenience, my lord. 77(2), my lord. Provided that no person who has received the amount otherwise than under protest shall be entitled to make any application under section 1 of the section 64. Well, no protest, deed of acceptance, they have executed. So they cannot go for a reference case. That has not been given, that right has not been given by this act. Because had they been not signed, had they been under protest, yes, they could have gone under 64, 64 minor. Now, your lordship, now how this minor amount has grown up to the nearly 410 acres, where this learned district judge has made a mistake. That your lordship will find in section 24. Lordship. This is multiple factor. Here, my lord, this is determination of your lordship what is section 24. Of land by contractor. Here, learned district judge has determined the price as per section 26(2). And under a notification issued by the Rural Development Government of India, and that is why it is shooted up to 400 crores. Just in concise, had it been come to 26(3), it had been 200 crores. In EBC, you will say that okay, district is right. Apart from we are deciding all these points, my lord. Here, if he comes to 26(3), my lord.
Then why you have said it has gone to 410 crores? Because of?
Because this is multiplication factor is taken wrong by 20. He is taking the multiplication factor on 26(2). Had districts have not been taken multiple fraction to 26(2), then it would have come down to automatically 410 crores to 205 crores. So if we assume that, if your lordship determines that this multiplication factor is wrong, even though the district judgment is allowed, it will come down to 205 crores. So as on today, only this multiple factor should be, the amount becomes half. That I have narrated on my grounds, my lord. Your lordship may peruse my 11, grounds 11. People know I can conscious with you. Yeah, this paragraph is very important. My lord, your lordship will find a page 35. I won't take much time, my lord, maybe maximum half an hour. That is page 35. Prior to reading this paragraph, my submission is that now the Deputy Commissioner has made the calculation.
Ground 11 you are taking now?
Yes.
Ground 11.
Page, yes. 11, page 35. Here, if the multiple factors had it been not taken in 26(2), then it would have come to the half of the price. May compensate if your lordship allows this is the judgment also. If interpretation, I mean, if this factor is not taken, automatically will come 200. It's a public money, my lord. We have been paying our tax from this tax has purchasing this collateral for security of and sovereignty of that. I will read 11. Why this is very important, my lord. I'll sort it off. This is only the 2 pages. That the learned district and session judge court has misinterpreted the law in awarding the multiple factor of 2 under section 26 of 2013 Act. The learned court failed to understand that the well-known fact that the ownership process is a non-cadastral step, which restricted market in the terms of buying and selling of land. The determination of market value as provided under Section 26(1) is not possible when there is no free market. It is precisely because of this reason, among others, that the state government notifies the floor price under Section 26(3). 26(3) of the Act. While determining the floor price under Section 26(3), the state government applied the principle to be adopted for the determination of market value by adopting the method of the, provided in under Section 26(1), wherever it is feasible and applicable as such as locational advantage and the disadvantages of the land. Therefore, the assumption of the learned court that the principle of Section 26(1) are not applied, while the determining of floor price under Section 26 prejudiced and they avoid any merit. Moreover, the learned court has partially interpreted the Section 26(3). The Section 26(3) of the Act specifies that the where market value under subsection 1 and 2 cannot be determined for reasons specified therein, then in those cases, the state government concerned shall specify the floor price, minimum price, calculated at the manner specified in subsection 1. In respect to the similar type of land situated in immediate adjoining areas, Section 26 and 2013 Act provides that this is the majority. Lordship has already gone through it. So I'm not burdening your Lordship to reading again and again. I'm coming to the last paragraph of page 36. A plain reading of the Section 26(3) of the 2013 Act amply clarifies that the floor price of the land is calculated in the manner specified by 26(1) in respect of the similar type of land situated in the immediate adjoining area. However, such is not the case where the instant land is questioned. Since the collector DC could not determine the market value of the terms of the subsection 1 and the subsection 2, the Section 26 of 2013 Act, therefore, he had to place the relied upon Section 26. And he relied upon the floor pricing specified in the state government 520/2022 notification, where it is 150 rupees, and made his recommendation and award in terms of 6/9/2022 notification in all at time. Section 26(2) of the LRA Act 2013 provides that the market value calculated as per Section 26(1) shall be multiplied by a factor to be specified by the first city. The same provision has to be been explicitly mentioned when the state government specifies the floor price to the land. The instant case clarified falls under the Section 26(3) of the Act, where it is concerned with determining the market value of the land based on the floor price. The learned court has unduly mixed the provision of Section 26(1), 26(2), and 26(3), while lawmakers have clarified, differentiated the procedure to be adopted to determining the market value of land. The learned court has on its own blurred and the distinction between the 26 and 26(1) by the arguing that the principle to be adopted in calculating floor price are based on the Section 26(1) without giving you diligence to the fact that they both are different in their intention. Well, this is some case law that has been given. So my humble submission for Lordship is that had it been come to 26(3), the price should have become a half. But we are very much sure that my lord, this case will be dismissed because it is on a fabricated power of attorney.
You arguing the entire case or only on the
It appears like
stay?
double argument is going on.
Whole argument is going on.
No, because yes, my lord, I said I'll take a half an hour with the case laws on this. Then Thakur will have sufficient time to argue.
I will also argue and finish it off.
My lord, I will not take much time. Then what happened, my lord? This is the actual factual case. Today, why before your Lordship? In the last occasion, my lord, your Lordship has said that the matter will be, the judgment of the learned will be set aside or suspended, my lord, on payments of some quantum of money. Your Lordship must have read that judgment in to the IA. That is, now my prayer is to stay the operation of the learned district judge, to give a stay, my lord. So for that, just I will give you a few citations of this Supreme
Where
Court.
you have said from where, when the order was passed on
Yeah.
the payment of something or?
Yes, that is in the last occasion, I think that order was passed. And you were said to dispose of the yeah,
I 231.
yes. IA number 231. For stay of the impugned order, judgment by court.
That is the I number 230.
IA number
231.
231 is judgment clear. This is not full argument, my lord. This is only for a humble prayer to stay the operation of the learned district judge. So I will read it, my lord. So this judgment was, I'll give some citation, not much, but only 8 citations, very short citations. So for your convenience, my lord, I have given the 2022 notification also. This is where the price is determined, 150 rupees per square meter. For your, this is a common.
What is this notification then? 2023, this one is also?
Yes, to how the state government has come to conclusion of 2022, 150 rupees per. That is the notification for your record, my lord. Just I'll give you the relevant portion, my lord. Just okay, your lordship may take the judgment. The first judgment is from the Allahabad High Court, my lord, and it was passed when our Justice Chandrasura, Justice of India, he was Chief Justice of Lucknow High Court, my lord. This judgment was passed. This is Allahabad High Court, Soyyed Wasif Hussain Rizvi. Your flag your lordship may come to paragraph 3, my lord. Paragraph 3 of this judgment. In subsequent decision of the Supreme Court in Surat Lamp and Industry Private in the state of Haryana, 2012 1, this is 560, the earlier decision of the so and so. Now here it is regarding a power of attorney. A power of attorney is not an instrument of transfer in regard to any right that will interest in any immutable property. The power of attorney is a creation of an agency whereby the grantor authorizes this grantee to do the act specified therein on behalf of the grantor, which when executor will be binding on the grantor as if done by him. Section 1 of the section so and so so and so. It is revocable and terminable at any time unless it is made irrevocable in a manner known to the law. Even an irrevocable attorney does not have the effect of the transferring the title to the grant. In more recent decision while elucidating the scope of section 138 of the negotiable instrument in 1881, a bench 3 of the learned judge of the Supreme Court, so and so, so and so, so and so, it says, my lord, the power of attorney holder is the agent of a grantor. He is an agent, my lord. While granting the authority to the attorney holder to initiate the legal proceeding, and the attorney holder accordingly initiates such a legal proceeding, he does so as the agent of the grantor, and the initiation by the grantor represented by the attorney holder is not by the attorney holder of his personal capacity. So your lordship may turn to last paragraph. It is a conclusion of this judgment. This paragraph 4. This is important, matter. This is the conclusion. What it says. Paragraph, last paragraph, 20, last button. 24. Having held so, we must at the same time emphasize the necessity of observing adequate safeguards. Where a writ petition is filed through the holder of the power of attorney, this safeguard should be necessarily include the following. Number one, the power of attorney by which the donor authorized this doning must be brought on the record and must be filed together with the petition and application. Number two, the affidavit is executed by the holder or with the power of attorney must contain the statement that the donor is alive. That question I have raised by law. One, power of attorney, he already passed it. The date of the execution of the power of attorney, he was not alive. He is alive, and this specified the reason for the inability of the donor to remain present before the court to swear the affidavit. And the donee must be conformed to those acts which he is authorized by the power of attorney of the child. Now, by the power of attorney holder, he cannot be the beneficiary. He cannot be the beneficiary. Here, the power of attorney holder, as he confessed before the district judge when he was cross-examined, he said so that he is having 50 acres of land. How he can become a beneficiary? How he can become a, on instant only he cannot become a power of attorney. The second judgment, my lord, your lordship will go. This is our two. This is, I have marked it, my lord. This is our Itanagar High Court, High Court order only. Your lordship may peruse paragraph 14. Therefore, in view of the matter, this court hold that the petitioner number 2 would not have joined in the writ petition as the petitioner number 2. And view of the judgment in the previous case of the petition number 1, that is Peno Enterprises, the court is compelled to follow the view taken in the same matter by holding the present petitioner number 2. Present the petitioner number 2 has no locus standi to file the present writ petition on behalf of the petitioner. Number 1 of the firm, which was unsuccessful bidding in the tender process. Accordingly, the petition is found to be not maintainable and same is this. When I said he is having a 50 acres of land, he is the beneficiary. So this judgment is sufficient for our High Court. The thirdly, I quote one more judgment from Kerala High Court, my lord. And this is State of Kerala. State of Kerala, my lord. And Sri Dharan Nayak. A relevant portion your lordship will find at page paragraph 24. Paragraph 24. This is Kerala High Court judgment. Where my kid is a judgment number 3, my lord. Paragraph 24. Not only I read only paragraph 24 only. Where the writ petitioner was having any material benefit, or was it due to the some philanthropy exercise is not the concern of the court. More so, when the writ petition who is given license to the practice as notary is vested with a certain function and duties prescribed under Section 8 of the Notaries Act. I'll not take time to reading those Section 8 minors. Such documents are to be made, used, and accepted by the various authorities in a different context by virtue of the relevant provision of the law, as discussed herein before, particularly with a reference to the Section 297 of the Code of Criminal Procedure, so money is attracted to the criminal procedurals. It was the above circumstance that the entire material were considered by the government when it was found in the option of the government that the writ petitioner was guilty of the misconduct of a such extent as to render him unfit to practice as a notary as contemplated under Section of the Notaries Act. Here, my lord, 102 people has notarized, and it is alleged that some of the signatures are put by the notary himself. Next is, my lord, there is a criminal appeal, number 4, I have noted it. This is a Bhagwan Singh. Bhagwan Singh. Here also I will read only just one paragraph. That is paragraph 29. paragraph 29. To create to assist the certain false document and to use them as the genuine known to be false in the court proceeding, to falsely implicated somebody in the false proceeding filed in the name of the person who had no about the same, are the act of attributed to the offense punishable under Bharatiya Nyaya Sangha 2023. There are also acts as frauds committed not on the person sought to be falsely implicated on the person whose name such a false proceeding are filed without his knowledge and the consent, but is a fraud committed on the courts. No court can allow itself to be used as an instrument of the fraud, and no court can also allow its eye to be closed in the fact that it is being used as an instrument of fraud. Here, my lord, this power of attorney holder with him is a fraud. Some of the reasons I have narrated your lordship also. Then, my lord, I'll cite another judgment. This is marked as a 5. This is state of, I forgot to just narrate one thing, my lord. CPC conduct. CPC. It multiplied. Judgment number 5. Here that I come you, my lord, how CPC narrates about the no deposit is required for the comment. Here I'll come. I forgot it. This is I placed before you. Here, my lord, paragraph 2. Paragraph 2. The only submission by the counsel for the petitioner is that in view of Order 14 Rule 8A of the Code of Civil Procedure, the appellate court could not direct the state to deposit a security defense of the case. For the reference of so no security is to be required from the government in the public office in certain cases. No such as mentioned in Rule 5 and 6 of the order shall be required from the government, or where the government has undertaken in defense of the suit from any public office, usually respectively alleged to be done by him in his official capacity. This statutory provision quote above clearly spells out that the court cannot order deposit of the amount when it states is the appellant by the depriving the benefit of the statutory provision. In view of this revision is accepted, the impugn order is set aside, extent the appellant is not required to furnish any background. Here, my lord, the CPC is very clear about it. The lordship will find that the order 14. 27 rule 80. What 20 or 27? 27 rule 80. Rule 27, order 27, rule 8. I forgot it actually. I should have been submitted earlier. Because today the case is about the security deposit, my lord. That is why I am coming to this point. It is no security is to be required from the government or a public office in a certain cases. No such security as to be mentioned in the Rule 5 and 6 of the order so and so shall be required from the government or where the government has understand the defense of the suit from any public office suit in respect of any act that is to be done by his official capacity. So, my lord, when this appeal is to be filed, so this judgment is relating to the number 5, my lord. No security is required by the government to deposit to hear the appeal. So next judgment, my lord. I have marked it as 6, my lord. This is only here on this. This judgment is from this court only. This last paragraph. As the connected appeal has been admitted for hearing, this court deems it fit to stay the operation of the impugned judgment and order till the disposal of in connection is ordered accordingly. In view of the provision of the the CPC, the requirement of the security as precondition for grant of stay is dispensed. That this is High Court judgment. So lastly, I will come with the 7 year. This is my lord Palm Developers Private Limited. This is only This is also regarding the giving the security only. This is just I will go for the simply footnote, my lord. The same would be explained government of a fund in the security where these orders mention the party direct or part deposit and the furnished security of the degree of the amount. The only provides exemption from the furnishing disability which would not restrict the court from directing deposit awarding the amount and part thereof. So part we are agreed by. That will come to it. Last judgment that is E, my lord. Number E. That is also from our court only. This is passed by Justice Sanjay Kumar Medhi. This was passed 26/24. Third paragraph is the operative paragraph. The aforesaid point rise being the pure point of law, this court is of the view that in case of exercising the review power of the made out, accordingly the order dated so and so has been reviewed and the condition on deposit of 50%, which was attached for suspending the award is removed. So here my question is whether now we have come before your lordship to give a stay of the order, but whether security is required or not. But I well understood that, my lord, there are so many judgments as my friend will submit it. And last occasion, before also lordship, I have promised to make some deposits. So we'll make a deposit of my lord 10% of the awarded amount as a security. Even though central government is not required to deposit any, and your lordship will stay the impugn order. That is my humble prayer before your lordship.
You're ready to pay 10%?
10%. On the condition of your lordship. And subsequently, my lord, why the central government has come with the security deposit, or the Supreme Court has come to the security deposits, because there is multiple the interest factor. And this amount will be in the court itself. Why, my lord, if it goes to the beneficiaries, suppose tomorrow your lordship will set aside the learned district of judgment, how this beneficiary will return the amount? So the case will be, my lord, it will be decided within 2-3 months. Till then, this 10% of the money that should be deposited in my court, deposited in the court, that is not to be disbursed to the beneficiary. So on your lordship will say the impugn order, then we'll deposit, my lord, this 10% of the security. That is my humble submission before lordship.
My lord, I stand for the respondents, landowners, respondent number 1 to 102. The arguments basically, my lord, it reminds me of Charles Dickens, my lord, Oliver. When Oliver goes and asks for, he is given only one spoonful to eat. When he says that I want more, he is bitten up by the authorities. Precisely, my lord, the Union of India is trying to strong arm us by selectively reading certain portions and certain things without specifically pointing out what was wrong in the judgment. The judgment, my lord, as all the arguments that has been placed today, the judgment has exclusively dealt with all the arguments except one fact, my lord, which I also admit, that one particular person, he had before the award, he had died. So when we drafted the petition, my lord, what had happened? His name, however, remained, but it should have been corrected as so-and-so represented by his legal heir, who is his wife. It is the wife who had actually signed. But then in drafting, my lord, the error remained that the legal representative so-and-so was not mentioned. And in fact, that error persists in their appeal also, because when they filed this appeal, my lord, at serial number 53, they still make the same person as a party, my lord. He still made a party, my lord. Whereas all compensation was received by his wife, and it is the wife who had signed it. That, however, my lord, I had already pointed out in an additional affidavit that had come. But then that will go more extensively into the merit, my lord. We need not dig into that depth of the matter, my lord. But then firstly, I should address 3 points basically. Firstly, they say that, my lord, that the power of attorney is not valid because the same was not registered. Now, my lord, have a look at section 17. Section 17 of the Registration Act gives a class of documents that are compulsory to be registered. So they had harped upon section 17(1) probably, saying that instrument of gift of immovable property is what they to be a power of attorney. But then power of attorney, in my humble understanding of the law, is a contract of agency. It is created under section 200 of the Contract Act, and that contract can be rescinded and it can be taken away by the person who has given it. Suppose I give my power of attorney to A, tomorrow I may revoke it. So it is between the executor and the attorney holder as to see what are the terms. By a power of attorney, I don't transfer any right, title, or interest. In fact, very interestingly, when the party was reading Justice Chandrachud's the opening line, Lordship must have noted, power of attorney is a contract of agency. It is not transferring any right. So since I am not transferring any right to anybody through the power of attorney, it is not a document that falls under compulsory registration under section 17. It falls rather in the class of documents in section 18 for which registration is optional. You may still choose to register it, but you need not also. Then he had moved on to briefly, my lord, section 32, because an entirely wrong picture of law was presented. Section 32 and 33 of the Registration Act, they say, for example, I am the power of attorney holder of a landowner. Tomorrow, as an attorney holder, I go to sell that particular land. Now, a sale deed is compulsorily registrable under section 70. So in that case, when I present the document of sale deed for registration, the attorney holder should be present along with the person who was there or who had given me the power of attorney. So that is the law of section 32 and section 33. It is not that a power of attorney is to be compulsorily registered, and because power of attorney is not a transfer of property, that proposition is very clear. And in fact, this was argued at length before the trial court. If your lordship comes to the issue number 1B at page 91, at para 50, if I briefly read, power of attorney is essentially a contract of agency, and such termination of agency can happen as per section 201 of the Interim Contract Act when the principal revokes the authority. It is also replied in the judgment of 2 and 2 so and so. That is one aspect. Then section 32 and 33.
These are already discussed by the learned
It's elaborately discussed. And what is more important is, my lord, is that when they come and say that how can a notarized document be presented, or see if the Evidence Act is taken, section 85. If Lordship is thinking of the new one,
no.
1872.
1872.
1872. Now it has become, I think, section 84 or something. Section 85 says presumption as to a power of attorney. The court shall presume that every document purporting to be a power of attorney to have been executed before and authenticated by a notary public or any court, judge, magistrate was so executed and authenticated. Now, there is a clear presumption in law in terms of section 85 That has been noted in para 55 of the judgment. Now it has become section 84. Now to rebut that, of course, they had the option to call everybody and ask them as witnesses that you want to disprove that I am not signed it. It was for them to call everybody and say that whether is your sign or not. That exercise was not carried out in trial. But just by simply saying that your power of attorney is not valid is.
He brought another issue that the signatures which are available in the power.
In fact, that has also been dealt with, my lord. That has also been dealt with. That has also been dealt with in the judgment, my lord. The court says that these two documents, they basically try to find out differences between two different documents. So the court gives a finding that these are horticulturist villagers. So they are not experts in writing or so. So minor variations here and there can come. So that itself would not dislodge the authenticity of the document. If that be so, they could have asked for forensic. If the signatures were so unbelievable, now in the appellate stage, can they raise this? And in the contract of agency, the people who are beneficiaries, they can come and say, of course, that I have not given you the power of attorney. Why are you filing a case and trying to take benefit from our land? It's not so. They had filed because collectively, rather than filing 102 separate applications, collectively, one of the landowners took the responsibility upon him to file the case. If your lordship looks at the power of attorney itself, what does he authorize? Or how is the power of attorney authorized? Page 213. It's not that somebody's right has been given away. In fact, the land, if they say it's a transfer of land, the land is already transferred to the government. It's no longer ours land, land is already transferred to the government, and therefore, the power of attorney thereafter is given at page 213 to pursue claim for payment of land acquisition compensation in respect of 537 acres, to represent, file reference court application for enhancement of compensation, and do all acts for this purpose, including to file evidence and depose in the court. And so all functions that are actually assigned to the power of attorney holder is to institute the litigation and file the necessary papers. It's not that the rights of the landowners have been obliterated and they have come forward, or somebody has surreptitiously or fraudulently has sought to be prosecuted, had come forward and is seeking to reap a benefit of its own. And in fact, the power of attorney is not there. In fact, I can also be not standing because my Kalarnama itself is also a genesis of that power of attorney, my lord. Questions are, my lord, frivolous in nature, as I understand. Yes, minor variations in signatures can happen of villages. Can that be a ground to not consider the case on merit? Secondly, my lord, of course, this address or these issues would be addressed in detail, my lord, in the final argument stages. But then more or less the reference court, what I wanted to point out, had looked into all these aspects. Secondly, they say that there was no protest. No, the protest, my lord. A protest does not mean that the day I am given the award, I have to go and shout outside the deputy commissioner's office. What happens in these cases is that these days the payments are electronic payments. So account details are already taken from the beneficiaries when the cost sheet is prepared. The date of award, the money is transferred automatically. So I don't have to come and say that I am receiving this amount with protest immediately, individually. Checks are not handed over that I take check and then I receive it on protest. So this entire context has changed. This aspect, my lord, is discussed in issue number 2 at page 99. Para 62, it says the word protest is not defined in the Land Acquisition Act of 1894 or in 2013. It is not specified whether such protest should be verbal or written. I'm reading from page 99, my lord, para 62. On the contrary, an application seeking a reference has to be a written application. So when I seek reference under section 64, you have to give a written application. Now, what the apex court says on this, my lord, para 64 onwards, my lord, there are 3 judgments quoted of the apex court. In as much as the appellants, I'm reading para 64 Ajit Singh, which is the leading case. In as much as the appellants have filed an application for reference under section 18, earlier it was 18, now it has become 64, that will manifest their intention. Therefore, the protest against the award of the collector is implied, notwithstanding acceptance of compensation. Why will I, if I am given 10 rupees for my land, why will I not first of all take it? Because my land is gone. The law says that after taking 10 rupees, if you say that, or if you can prove to the court that you are entitled to more than 10, you file a reference application. So that reference itself is a protest. Para 65, Sandrabhan also, my lord. Para 65, my lord. In Sandrabhan also, the same finding is returned by the apex court. It says, consequently, protest against the award of the collector was implied, notwithstanding acceptance of compensation when your reference application is filed. Then, in a more recent case, para 66, my lord, page 101, 2017-14 SCC, the apex court says that once an application under section 18 of the act is filed, presumption under the law is that the owner or the person interested in the land has certain objections with regard to measurement of land, amount of compensation, 3 persons to whom it was payable, and apportionment of compensation. So the law does not require that I should raise hue and cry and say that I protest. The application itself, if it is made within the time, a time frame of 6 weeks is given in the statute. So from the date of award, if within 6 weeks I come and file an application, that application itself is the manifestation of the protest of the individuals. Because land is a very variable right, it cannot be taken lightly. This person whose land is gone, it's gone forever. The generations will not get it back. So therefore, they have every right. It is an important facet of 300. And also it is being again equated to also certain rights under Article 21 also. Because without land, people are nobody. They are in fact totally displaced. And what is more important here, because Lordship was being pointed out about urgency clause in section 14. What happens in the scheme of the urgency clause is that you don't have a right to protest against the acquisition of the land itself. Otherwise, you can say that no, it is not required for public purpose, so I can protest. So that is taken away, firstly. And secondly, your the right that we have in land acquisition matters of rehabilitation under the 2013 Act. 2013 Act says that you not only have to be compensated, but then if you're displaced, you have to be also rehabilitated. Now, when urgency clause is used, however, I don't get any rehabilitation also. So my agricultural land is gone. I don't have any alternative land. So now I therefore need the money compensation that I get there to be able to buy some other land of equivalent quality. So therefore, these issues are to be looked into a little bit deeply and not just in a superfluous manner in which the matter has been projected as if it was an afterthought that had come and people had come and projected as a fraudulent case trying to reap the benefit of certain benefits. The judgment, therefore, is, I understand, to be a very thorough judgment which has looked into every aspect of this matter, like the deed of acceptance that was read out. The deed of acceptance, your Lordship had seen, is again a very suspicious document, my lord. what had happened, if your lordship was looking at probably page if your lordship was looking at page 399, firstly, there is no date. And the first two pages, which contains the, if I look at the page 399 and 401, the first two pages of there are two pages only. This does not bear signature of anybody, not even the deputy commissioners. So our case was that you had used this page 402 onwards, which was basically our name and photo identity verification, and you have appended it to the first part and said that we have accepted the compensation. That was a triable issue that had been also looked into by the trial court as to how and what discrepancies are there in this particular date. But then I'm not going too much into facts. What this did therefore says is firstly that we accept compensation of this total amount of 69 crores something. Acceptance itself, as I read from this 3 judgments of the apex court, acceptance itself is not a foreclosure of rights under the law. When the law gives you a right to file an application, this deed cannot be used to prevent me from filing a reference. That we had argued in terms of also section 28 of the Contract Act. Section 28 of the Contract Act says that there cannot be any agreement restricting initiation of legal proceeding. That has gone into by the trial court clearly. And why therefore I emphasized on this last part is that this deed of acceptance also says that it is an integral part of the compensation procedure subject to provisions of the 2013 Act. This deed, whatever be it, it cannot take away the substantive rights that are created under the statute. The statutes give me a right to object. The determination thereafter, my lord, yes, may be correct, wrong, the amount may be high, the amount may be low, is a matter of that is to be looked otherwise. So it's not a case where that we had come in a very frivolous manner, or this had prevented us, my lord, from approaching the reference court. That is also quite elaborately dealt with. And in the arguments and the grounds also that I have found that this thing, the core of our argument has not been negated. What they had said, my lord, is that the rate would not have been increased from 120, 150 to 500. Now, how do we increase rates in land acquisition cases? Lordship knows that there has to be an exemplar of sale rates of neighboring areas. And there is another method, what is called the cumulative escalation method. Both these are time-tested methods evolved by the apex court. In comparative sale method, what we do is that we find out the average price from different sale dates that are there, which you think is relevant. 9 sale dates were exhibited. From there, the average value was coming around 506 rupees. And also, if we try the cumulative escalation from this 150 rupees, why that was required? It is because it's an interesting twist here. They wanted even the revenue department to come and join and say that you justify that these rates are correct. But then from the affidavits of the revenue department also it comes out that these rates in Arunachal Pradesh were rates that were fixed in the year 2010 and 12. Now, what the apex court says that everything is escalating price. 2010, what was the price of 1 kilo of rice? And look at the price now. There is a natural inflation happening everywhere. So therefore, land price also will also increase. Therefore, you cumulatively taking 150 as the base rate, you cumulatively increase it. So that cumulative escalation also comes to around 500. Only error that might be there is that maybe the base year, the reference code had taken to be 2010, whereas the actual government notified notification is of 2012. So therefore, I think this 500 could have been actually or should have been, even I should candidly submit, it should be 426 or something like that. So that escalation has come because of taking of the wrong base here. So these two try and tested methods were taken, and they have evolved this technique of determining the market value, and accordingly the market value had come. The last aspect that they are attacking on us is that they are reading section 26, 1, 2, and 3. And I don't know how lucidly it could have been explained. 26.1, as I know, says that based on value you determine. Then under 26.2, you give a multiplication factor. Then
He is insisting on the multiplication factor, there is an error in taking.
yes. Then you add on solation. These are statutory benefits. These will automatically add on. Once you determine the market value, the statutory benefits will automatically add on, including interest. There need not be, the law is very clear, there need not be any adjudication on that. Even if the court does not grant it, it has to be added. Because the statute provides that you will get solation, you will get so. They say that multiplication factor is not applicable here because you have taken a state government notified rate under 26.3. But then we had placed judgments and previous precedents before the court, which is clearly discussed on the aspect of multiplication factor. Lord, you will see there is a elaborate discussion in the judgment. I would, in fact, because of scarcity of time, I'm not taking your lordship through the judgment. Say, for example, the sale deeds that are referred to at page 136, all the sale deeds are there. Lordship would have a look. Page 136. Lordship would see rates of 18,000 also is there, 10,000, 3,500. Of course, these are skyrocketing prices, they cannot be taken. So the method of averaging has to take place as to the area and what we call a development cost. All these methods were applied, and thereafter the deductions, after making all deductions based on Supreme Court judgments, the price was reached from what was reflected in the sale deeds, and it came to ultimately, my lord, a rate of 500. Then this cumulative escalation aspect, lordship would see, is at page 152. This has genesis from the Ramesh Jivan Bhai case of Apex Court, I think, which has recently been, I think, reiterated by Justice Surya Kant in Central Lower Housing. Both these judgments are cited, and also I think New Okla. All these judgments are cited because you cannot freeze the market value at a particular year and then say that no, you take it because that is the government ratified rate. Government themselves say that we have not revisited it. So is it not therefore the duty of the court to revisit it and give us a fair compensation? The name of the act itself is fair compensation. It is not just compensation. So considering all these aspects, my lord, the judgment had dealt with every aspect on the basis of certain law that is there as given in the Apex Court judgment. Your lordship would still because it's a statutory appeal, of course it deserves admission. So to the admission of the appeal, there was no objection. Lordship would rehear the issue and see if, of course, like I submitted that even I feel that 500 may be high. It can be actually 400, somewhere around 400 because of the base year, the error of the base year that has happened. So definitely there are issues to be reviewed here. But then it's not a case where there is nothing in the judgment. It is just to be washed away like that. Now, coming to the issue of security, your lordship probably had given a copy of what was the judgment of Justice Nariman in Palm Developers. If your lordship has a copy, just invite your lordship to have a look again. Is your lordship having a
SCR citation. The citation is SCR. Farm Developments Private versus State of West Bengal. এখানে দিছিলে জন্তু।
Oh, আচ্ছা। Just
SCR.
2019 9 SCR 252. This is actually highlighting a very important facet of CP and how we can, like, certain provisions, if they are there, how they are rendered redundant over a period of time. 2019 9 SCR 252. Don't you have? Probably I have a digital copy only, my lord.
give this one only.
If your lordship have it.
You have already provided us.
Yes, I have.
Yes, but then I will read a different para, my lord, of the same judgment.
Judgment number is given by the lord. With a pencil.
19 SCR.
Because order 22 rule 8A is no doubt there on the CPC, which says government need not pay any security.
Marked it as 7.
Yes, I have given.
7 one on the 7.
Because he had referred to it, my lord. I have a soft copy only.
Yes, that is one. Yes. Yes.
Very importantly, lord, you could just have a glance at
You
para.
want 2019
Yes, my lord.
SCR, na?
SCR. If your lordship
Not,
comes to para 22. Because they try to demolish this case of like having a
In your
requirement
para
of people.
9 starts from when?
Para
Your-
22, if we start, my lord. Further, it is to be noticed that order
Okay, yes.
27 rule 8A of the CPC was inserted in the year 1937.
Yes.
In the year 1937, when the British Crown was ruling our country, the same was brought during the period of the British Raj to protect the interests of the government crown. While considering a case where we Bengal so and so, that is there, the last italics part I will say, my lord. There are many reasons to why the said construction is inconsistent and incongruous with the present setup. We have no crown. The archaic rule based on the prerogative and perfection of the crown has no relevance to a democratic republic. It is inconsistent with the law, rule of law based on the doctrine of equality. So this aspect of Order 27 Rule 8A in the CPC, though it has still not been struck down by the legislator explicitly, has been read down by the apex court, saying that you cannot, in a democratic government now, bring in protection that is there or was incorporated to safeguard the crown, because the crown was supposed to be absolute. But here government is not absolute. Here law is absolute, my lord. There's a difference. So in this case, ultimately what had happened is that it was said that it's not just security. Order 41 Rule 5 says that when you come for stay of a judgment, and when it is a money decree, the court would require the deposit of certain amount. I think this line was already read, that order rule 8A only provides for exemption of anything security, which should not restrict the court from directing deposit of the awarded amount and part thereof. The judgments that has been placed, I think these are not judgments as such, simple orders that otherwise where in some cases our High Court has said that it is not required. But I see that recently, I think Justice Medhi's one order was there in a review petition. That review petition I just browsed through was a case where a person, it is a railway accident claims tribunal case. So the different context altogether. The person was traveling without any ticket and there was no proof also brought in there. So in that case, of course, bona fide person who does not have any proof as to whether you are a bona fide passenger or not cannot be also given a interim benefit. Here in this case, there is no doubt that we are the bona fide landlords. Do they say that the power of attorney is so and so, so and so?
Now,
It cannot be read down in that
now
manner.
they are agreeing to,
My lord.
10% they're going to pay.
My lord, now I'm coming to that. Just I had clarified that security aspect and the deposit aspect are two different things. Now, land acquisition, as I had pointed out, my lord, is a very sensitive matter. Therefore, my lord, I had made a compilation of, my lord, around 7 Supreme Court orders and 3 also passed by our Honorable High Court. If your lordship has a look, the consistent approach that was taken, my lord, in all cases is that a 50% deposit of the enhanced amount has to happen. Only exception I find is in Niara, where, however, even though 100% was to be deposited, only 25% was allowed to be withdrawn. Then serial number 8 and 9, my lord, these 2 cases are from our, one went to the Supreme Court. The Bhasis Board was appearing, and interestingly, I was in the receiving end at that point of time. I was in the government at that point of time, my lord. So in these 2 cases, over 50% of the Ministry of Defense payment had come. Finally, Union of India Darji Khandu Sukla, which is also a case decided very recently by this court, by Justice Kadar, that went to appeal. In that also, my lord, we have a liberty to withdraw 50%. The question is, of course, when you withdraw amount on an interim basis, you have to furnish indemnity or a surety bond. On that basis, it has been generally working over a number of judgments. I can produce a number of judgments because these will not be judgments, my lord. These will be orders only like what we have in the last 3 parts, my lord. Because in most of these cases, my lord, reasonings are not very detailed. Recording or reasonings do not happen. But then in the first 7 judgments, my lord, lordship would see a consistent, my lord, approach has been taken by the court that even in some cases, 100% deposit. Why it has become important, my lord? Why this approach has been taken, as I understand, my lord, is in land acquisition, your lordship knows that the interest is very high. There are interest of section 80, there is interest of section 72, earlier it was section 28 and 34. Both become 15%, my lord, after 1 year. Initially it is 9%, after 1 year it becomes 15%. So if the case takes 2 years to decide, the amount, my lord, it grows manifold, it becomes double. In some cases, we have been also in the receiving end, where we have ended up paying, my lord, more interest than the principal itself. So therefore, this device of, my lord, depositing some amount had been evolved. This has a balance basically, because ultimately it saves both the parties. And as I said, my lord, it's not a frivolous case that all of a sudden, my lord, the court had enhanced the amount without any foundation and without any basis, my lord. And 10% have found that, my lord, yes, in all cases, courts are awarding 10%, my lord, I could have agreed. But then in all cases, I find, my lord, 50% is the basic norm that has been followed. Maybe, yes, I understand. Maybe if they say that the amount is too high, maybe it can come down a little bit, maybe to 40%, maybe to 35%. But then how can it go below that? Because we have also, my lord, our interest also has to be seen. Our interest also has to be seen. We have been displaced of our agricultural land. Tomorrow, I just give you an example, my lord, last. At 1 square meter, they say it's 150 rupees. 1 square meter, I grow 4 cabbages, 10 rupees each or 15 rupees each. I get 60, 70 rupees. So in a year, I can generate around an income of around 200 rupees from 1 square meter. If it's horticulture, if I put an orange tree, 100 rupees per kg is the minimum mill. So 1 year I generate 250 rupees. How can you give me 150 rupees for the entire lifetime? My land is gone forever. So all these considerations
It's
are to
okay,
be there.
but if you see the earlier compensation award was around 69 or 70 crores, I
70
think.
crores, about
70 crores, almost 70 crores. That has been increased to, as per him, I have not done for him, 410 crores, whatever.
Why it has,
So enhanced amount, if you see, then definitely if you go by the 50%, quite a big amount.
why it had gone up, my lord? What had happened earlier, they did not add the multiplication factor. Earlier, it ought to have been 140 crores earlier. They did not add the multiplication factor. Now, therefore, it's looking big. They said that it's not applicable. But then this is a special case. What 26(2) and this notification says that when the central government is the acquiring authority, the Ministry of Rural had clarified that it would be a multiplication factor of 2 for all rural areas. They, of course, now seem to distinguish that also by saying that some interpretations of this circulars are there. Of course, we'll interpret them. We'll interpret them later on, my lord, when the hearing comes. But then, this multiplication factor aspect was skipped earlier. So therefore, this what ought to have been 140 was earlier 70. Now, with the enhanced amount, my lord, if the multiplication factor is a multiplication factor, my lord, is a statutory benefit, my lord. The statute says you have to get it. Yes, of course, there's a mode of determination. The relevant notifications have to be looked into as to how it is determined. So once that is added, my lord, you cannot just simply say that you don't get multiplication factor. The argument of 26 to 23, they do not hold anyway. In fact, in before Justice Carter's judgment also, this was argued, my lord. They are trying to formulate the same question of law in Supreme Court also, in the last case that I have referred to, my lord. Supreme Court has not till, however, now formulated any question on that. That will, of course, remain open for argument. And therefore, I am, of course, of the considerate view, my lord, that yes, I understand state, of course, they cannot say that they will go bankrupt. But then we will go bankrupt, my lord. We have been displaced. Tomorrow, I cannot find any land, my lord, with the price that I have got. I cannot find any alternative land because we have not been given rehabilitation also. So if some temporary relief is given, my lord, at this stage, my lord, like has been done in all cases, may not be 50%. I will leave it to your lordship's wisdom. May not be 50%, but then with the liberty to withdraw with security. That is the order that wrote in all cases, my lord. What's the point in keeping the money in the registry? It could very well lie in the central government itself. The idea of giving this payment forward is that once you received it, then yes, the interest ceases to accumulate on it.
But generally, it will be, I mean.
Normally deposited in the executing court where we withdraw by giving security and indemnity. Lordship is probably dealt with this matters in as a district judge earlier, madam. Because that's the law.
Yes, Mr. Dole, anything?
Yes, my lord, because this is the fourth argument regarding this.
Different, 4 different judges we have argued.
Yes, my lord, 4 times we have submitted.
Nobody has come to a conclusion.
Then, of course, my lord, because Union of India actually formulated and Supreme Court has so many orders to save the interest of our. But my lord, suppose some amount is going to the beneficiaries. Suppose tomorrow your lordship stays aside the order, how that money will be recovered? That is the one of the questions. Because these are landowners, they are poor people, most of them poor people, I don't say all. So it will be impossible to recover that.
I think
So my humble submission is 10% will deposit in the court, not disbursed to the beneficiaries. So the impugn order will be stayed. So as concluded, that is my answer. Then we'll see at the time of hearing, this matter in your hearing will not take much time. I think within 3-4 months during hearing included.
If it is not suppose disbursed, then again.
What I will say, they could have, my lord, and just lordship at the compilation, my lord, that I have given.
Oh, yes.
The last order, my lord. before Justice Gawai and Justice Narasimha. Issue notice. Mr. B. Pathak, Learned Counsel for the respondents, appears and accept notice. Until further orders, there will be stay of execution of the proceedings on the condition of deposit of 50%. Reference code as affirmed by the High Court within 12 weeks before the reference code. Said amounts will be permitted to be withdrawn by the respondent by considering a furnished solvent securities to the satisfaction of the executing court and file an undertaking and affidavit to the effect. This is how, my lord, every time, my lord, the matter is taken care of. In fact, Justice Devasis Boro was lucky earlier when, if you look at the earlier two orders, in those two cases, my lord, withdrawal was permitted, my lord, without any security also. Without any security also.
Because what happened, my lord, here, if we determine, okay, if we take a multiplication factor in my part, okay, multiplication number 3, it becomes only 210. It becomes how? Suppose if this judgment goes against me also, or it is amended also, if this 210 crores, now 10% becomes a 47 crores because 400 and plus 70 crores we have already paid. Total 480 crores. This 10% itself is 47 crores. So already 70 crores we have already disbursed. The rest will be in the court, my lord, till disposal of the appeal. And that is a matter of 2-3 months.
No, it cannot happen 2-3 months because the same issue, as I pointed out, the bill is pending in the Supreme Court. And the two last cases, my lord, I had also referred to here. LA Bill 2017, when Justice Adit Bhattakur had passed an order, because its connected appeal is on the same issue is pending in the Supreme Court since 2017, the state LA Bill is still pending. Because your honor would not come into seas on the same issue, which are already taken up to the apex court. So it's until something more concrete happens in the apex court, my lord, on this issue as to multiplication factor applicable in Arunachal, whether government notified rates can be changed or until something happens there, the quietus has to be maintained, my lord, probably. And if not, at least not in this manner. So therefore, our balance, this 50% rule is therefore a perfect equitable balance. It does not hurt anybody. It does not hurt anybody. All we get is basically what is our due, which has been already, the judgment has already gone against them. We are on appeal. On appeal, we have to see only where the court below has gone substantially wrong. As I pointed out, there is no substantial error as such. All judicial precedents have been followed. It is their error that they gave us rates of 2012 in 2024. Therefore, this difference is coming. 2012 rates were given in 2024. Differences are bound to come. You don't give us multiplication factor, differences are bound to come. And now you say that it's an astronomical amount. Look at the volume of area also. It's 537 acres. In fact, I understand Order 41 Rule 5. It's mostly a discretion of the court. And then, of course, this discretion is Lordship's equitable discretion, as I say. Lordship has to strike a balance and see that we are also not put into hardship. Tomorrow, if this litigation goes on for 10 years, how do we fight the litigation also? We don't have land. We are displaced from our original agricultural land. There's no rehabilitation. All these equities are to be looked into, because ultimately, of course, Order 41 Rule 5 has got these orders of the apex court that I have produced also. It's past an equitable consideration. Because merits, at this stage, we cannot. If we go too much into merits, my lord, of course, we can better dispose of the appeal itself today. All these aspects that we have argued, I had only rebutted him because some serious aspersions on our conduct was casted, as if the judgment is not based on any foundation. It is a whimsical thought of the learned reference group. I address it, Your Lordship.
So might just stumble on unfair. I love my, and this reiterating my lord, some amount goes to the beneficiary. Beneficiary won't be able to return it. These are poor people.
How do you
And my
tomorrow will become rich. If you give us the money, it will
and
become
10%
rich.
is also not small money, my lord. That is why my prayer is the money should be deposited in the court itself. That should not be disbursed to the beneficiaries. And
No, I would have,
3-4 months.
I would have agreed to the proposition had he shown one judgment saying that this is what is done in land acquisition cases, that money is deposited in the court 10% and not paid to the beneficiary. So was one judgment. My lord, I will humbly surrender.
So before
Humbly surrender and.
Lord, the reward, so increasing my submission may be noted. You say 10%, not to the disbursement to the beneficiary. My submission may be noted. by
Yes,
lord.
yes, I have.
After that is your lordship discretion. Absolutely.
Lordship, but it's most of the cases, the land acquiring cases are, lots of land acquiring cases are there.
As of now, my lord, a lot of projects are coming up.
No, reason being, Mala, there is a threat from the foreign countries, and that is where this boundary is to be.
Not only
In
that,
your-
my lord.
Not only in.
The other day we were doing a hydro project case, my lord,
yes.
with Mr. Agarwal. So this kind of infrastructural projects are
Yes,
coming
a
up.
lot of infrastructure.
And in fact, therefore, prices of land is not just 500, 2,000, 5,000 also you will not get land. Actual, the market condition is like that because of these infrastructural developments. And here, everything is not habitable. Only thing that is nearer to the highways is habitable. The prices are very premium. My entire bar is sitting behind me, my lord. They would know better. That 400, 500 rupees is, I don't know where they get land at this price these days, my lord. But then anyways, we have to go by the rules that are there. So the rules and the law saying that we can come to a maximum of this. So I will consider it maybe should be a little bit less. Well, as of now, some relief to us is always one.
Already.
Deeply obliged.
Will be, delivery of order for
I have not marked the paras here, but then I'm just given a small chart here, lordship. These are short orders that are there. Yes, yes. Short orders only, lordship, just have a look.
Oh, yes. Okay.
My lord. This is the one coming Wednesday.
Yes, sir. Oh, yes.
Oh, I understood. In fact,
Yes, yes.
lordship also pointed out last time not to
Yes.
fix matters on Friday.
Alright, sir.
Or if some difficulties there, we are both from principal bench, my lord, can render it in the principal bench also if some time is required. I'll only invite your lordship to go to the trial court judgment once. I think that will clarify the whole issue. That will clarify the entire background of the case. Deeply, deeply obliged.
Yes, 17. Yes. Lordship, last occasion TCR was called, Lordship.
TCR has not received loss. I have checked loss. TCR has not received check loss. Not possible. Lordship, it will be convenient to go to the record, Lordship, because here, Lordship, they have come revision petition challenging the order, Lordship. Yes, Lordship.
Lordship, it's second time, Lordship, it's session UPI only, Lordship, session code is step. Lordship. जी नहीं Lordship.
That's, and this month only lawsuit, this March lawsuit.
February, yes, Lordship. February 4th,
Lordship,
Lordship.
one time it was called and it has come lawsuit, but the wrong TCR has come lawsuit. That was I applied on the last present. Yes, lawsuit. Then again, court has called another this yes, the appropriate TCR lawsuit.
Lordship fixed date may be given otherwise, Lordship, because Lordship matter is fixed on 1st of April, Lordship. Yes, Lordship. Otherwise, Lordship, this petition will be infructuous, Lordship.
March it would be fine because it's nearby lawsuit. By that time it will reach lawsuit. Yes, lawsuit.
Then Lordship, last opportunity will be given, Lordship. Otherwise, Lordship, this is two Lordship, no, Lordship, two.
Not our for lawsuit.
Lordship, then on that day, Lordship, matter may be disposed of, Lordship.
Mhm.
Are available here.
Yes, Lordship.
No, order they have
Order is-
annexed lawsuit.
Order I have annexed, Lordship.
Or if the other, the documents would have been available in the court, and necessity of the TCR, calling for the TCR may not be so there, but anyway, we'll definitely show cause the land trial court will, if or not before the last application. So I'm asking you whether 24th will be proper for you, 24th,
March 24th.
24th of March, or 20, or else we can give.
Lordship,
0.
then maybe fixed, Lordship.
Huh?
Next week.
Next week,
Yes, Lordship.
19 it may be fixed.
then
lawsuit.
19, okay, 19.
Okay, Lordship,
Okay.
fine.
19.
Of like lawsuit.
Much obliged.
May I, my lord?
Yes.
Today itself, my lord, I have filed my Bakalat Nama, my lord, in item number 18, my lord. I may be given
On behalf of this
a respondent.
respondent.
Yes, my lord. I may be given at least 4 weeks time to file counter affidavit, my lord.
You are Mr.
T. Minky.
T.
T. Minky.
The petitioners had remained absent on call. Heard Mr. T, who appeared on behalf of the respondent and filed his Wakalatnama today. And accordingly submitted that he needs 3 weeks will do. 3 weeks will do?
4 weeks, my lord.
No, and he needs some time to file their counter affidavit. Prayer list the matter accordingly after 3 weeks, enabling the respondent side to file their counter affidavit. Now there are hearing on one RSA was there.
Yes.
I don't want, yes.
Your lordship, I think it will take time. Therefore,
No, in part third matter, I don't want to keep any part
Yes.
third matter because next bench when I don't know when it will be there. In the month of April, my bench is not, will not be here. For
Yes.
This. So RSA, then definitely due to paucity of time for it.
so
After 2 weeks or 3 weeks.
no,
we will-
your lordship, since I'll require a fixed date. So this may be fixed on
You want a-
21st
you
of
want a
April.
fixed date here.
Yes, because there are some technical difficulties we have to discuss. 21st April would do after the vacation.
First
Yes.
of April,
21st.
after view vacation.
Yes, yes.
Request for it, 21st of April. Okay, we're listing it on 21st of April.
Yes.
So you are for the whom?
I am for the
Respondent or appellant?
appellant.
For the appellant.
Yes. Raksa.
22 who is appearing, criminal appeal.
Deeply obliged.
Please, my lord.
You are appearing in
Milord,
which lawsuit?
item 22, I am appearing, Milord. Milord, this matter will be taken up tomorrow, Milord.
No, not tomorrow.
So,
Other matters, fixed matters are there, not tomorrow.
otherwise on Monday.
Next Monday.
Next Monday.
It is urgent.
Yes, this is appeal.
Person is in jail or what?
Yes, inside the jail.
Inside the jail?
Yes.
Why it is not written as a jail appeal? What says it is appeal by from the side? Otherwise, person is in jail.
Yeah, person is in jail.
Monday may not be possible. Take it on Tuesday, that is on 18th.
Tuesday,
Okay.
Tuesday.
Tuesday?
Yes.
Next Tuesday, 18th.
Grateful, Milord.
18th.
May I please, Milord, item number 24.
You are on item number
24, Milord. So for this matter is concerned, Milord has already dealt in another similar matter. It's on the illegality and perversity, infirmity of the bail order passed by the session judge. So for the point is concerned, it's in a very short matter where even I argued on the last occasion where Justice Gooding gave it as CAV. Thereafter again he has released on the ground that it's a local. So my point is on a low point only on the perversity and the illegality. So if your lordship is pleased, Milord, may you kindly fix on 13 at 2 p.m. because lordship is already.
We are not fixing any date on 13. You are from principals. Go ahead.
Yeah, not. Therefore,
so we are going to stay up to 13th.
No. I'll stay up to 13, Milord, at 2 p.m. 13 because.
Oh no, we are leaving on 13. We are not fixing anything.
Because your lordship has already heard on a similar point. Because similar point in other matter. That was your lordship has passed the order in 9 January 2024 in one POCSO matter on the illegality and infirmity and perversity of the order passed by the session judge, that is a special court, on a bail matter. Mine is for setting aside a bail matter. 13 at 2 p.m. Milord, because
no, we are not. Tomorrow, how many matters are there?
Tomorrow, Milord. Otherwise on Monday then in that case.
That's just Monday. Monday will be there. Wednesday we are not in a position. 13th we are not in a position. 13th is not be possible to take.
What about 12, Milord? 12 day after tomorrow. 12.
12 also division benches there. No? 12 again same thing will be division benches there and then. Tomorrow he is having some problem. You're having
tomorrow I'm saying.
You are appearing here? Yes. And private respondent are also there, I think?
Yes, Your Honor.
You are for the private respondent?
Yes, Your Honor. Milord, if
at
I
least
cannot,
on 12th. 12 will be.
12. If I cannot complete on 12, it will go. But at 2 p.m. at 12. At 2 p.m. So that other matters can be all soon after. Because just my learned friend will understand the matter. Because your lordship has already passed on the same law point. If I can satisfy your lordship, I mean, otherwise I'm out. Because it's only infirmity and perversity of the bail order passed by the session judge in a heinous crime, that is in 302. The consideration that was done by the session judge was that he is 70 years old man. There was a consideration. 12. Will lordship please? 12 2 p.m. Milord. 2 p.m.
At 2 p.m. 12 at 2 p.m. Okay, we're fixing it at 2 p.m.
Milord.
So you're going to stay these days here at Onachal?
Milord, I have got a virtual hearing tomorrow. It will take very long. That's why tomorrow is very.
No.
12,
no, I'm not on that. You're going to stay up to 13 here only.
Milord.
Oh.
Till
Other matters also.
Other matter. I'll wait for this.
You are dealing with the case or in leading counsel is anyone else?
Leading counsel is Tawatagu.
He is already.
But Mr. Tawatagu, some difficulty today, I think.
No, he was here today also. Just he is informed me.
He is ready to argue the matter.
He is ready to answer.
Okay.
Oblige, my lord.
You also have come from same matter? Same matter?
Yeah.
Mhm.